Yes.
For inclusion in the list, my lord.
Under what heading?
My lord, motion.
Motion hand over the slip.
It was in the list prior to notify. It was in the list.
Motion.
Motion.
It went out. Why?
I don't know.
Hand over the slip.
Read solely.
Motions, please hand over the slip. Contempt. Contempt, please hand over the slip.
Grateful, Your Lordship. In the last occasion, that is yesterday, I mentioned the matter,
Inclusion.
but due to non-clarity of richness and importance of the case, requisition has not been sent yet in the department.
The equation has not been sent.
I have written that.
All right. Will take some time. Requisition will be sent. Files will come. Sir, please, you have to accommodate.
Private respondents are constructing illegal construction. We are absolutely blocking our egress and ingress to our home.
I will consider. Yes.
Lordship, may I be permitted to mention one matter for inclusion, new motion?
New motion, please hand over the slip. You did
My
not
lord,
mention. Please hand over the slip.
My lord, new motion, my lord. I am a 79 years old lady, my lord.
Sir, please hand over the slip.
My land has been acquired, my lord. That is.
Yes, Mr.
May I
Banerjee.
mention one matter for inclusion has to be mentioned, my lord.
Why?
Because, my lord, in this matter, my lord, challenging order of the appellate authority under the Metro Railway Act. We have challenged it. This honorable court, while admitting the motion, my lord, directed that the admitted amount may be released in our favor either by bank draft or by way of bank transfer. That, my lord, the authority is not giving, citing defects in the affidavit in which not the account number is given. Only one clarification is required that they can not release it by way of bank draft also. We mentioned on 29th of October before the change of determination. His lordship directed that it shall appear as to be mentioned on 3rd, 4th.
To be mentioned.
Yeah, only one clarification is required.
You have said that for clarification in the mentioning slip. Please indicate that to mention for clarification. Yes, call the list. Yes, Mr. Banerjee, you are appearing
I am for the appellant, my lord. This matter.
You are for the appellant, yes.
This matter was mentioned.
You are for the respondent.
I'm for the respondent.
Mentioned-
This
mentioned
was
by the-
appearing at our instance. This matter has appeared at our instance because we had earlier filed an application seeking recalling and modification of the order, which was not allowed. Thereafter, we carried that order to the Honorable Supreme Court. Considering the pendency of the appeal, the Honorable Court directed the appeal be disposed of within 3 months. So it's their appeal. I am given to understand yet paper books have not been filed. Paper books have not been filed. While we have to assist your lordship, we have prepared a compilation.
6th of October. Mr. Banerjee, tomorrow.
Some paper book is ready, but some further.
Mr. Banerjee, when this attention of the order has been drawn, 1 month, more than 1 month has expired. It's only 3 months' time.
So we were not present at the time of hearing of the SLP.
That's neither here nor
We
there.
shall be paying for 1 week's time for filing.
You are
the
a
paper.
party, you are bound by the order. More so, our direction is binding upon this court. So,
We shall file it by 1.
yesterday it was brought to my notice.
Right.
I've directed, this is the first opportunity, I've directed this matter to be posted under the heading to be mentioned. Please get
One-
ready tomorrow.
No, 1 week for filing the paper book because the documents have to be documents have to be filed. The
Second
paper-
appeal, what documents you will file, Mr. Banerjee, in the paper book? You are submitting, Mr. Banerjee, second appeal. What are the documents which are necessary in the second appeal paper book?
file question ki?
It's not a
No,
first appeal.
No, only the
Then
memo and the 2.
how much time it takes to prepare a paper book of a second appeal?
Shall-
1 day is sufficient.
We shall file by the course of this week. Kindly take about Monday, Miller. No, for
Please
getting
file it by
prepared,
tomorrow.
No, it has
I'm
come to my knowledge
keeping
today. For getting prepared 1 day only, your lordship is giving.
You are
Miller.
prepared, Mr. Banerjee. You are the appellant. You have got the appeal admitted. Mr. Banerjee, because more than 1 month has expired. Now, one of you will go and say that there is a violation of the
No, no,
timeline.
nobody will ask for any adjournment. Kindly give us some time for preparation, Miller. Not tomorrow, Miller. Any day.
Court also has to get some time to deliver the judgment.
Not Friday. Can you keep it on Friday? We shall do it this week only, my lord. Friday.
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 Yes, Friday, you,
Second,
file the paper books, serve them by Friday,
my lord.
and the if you want to file the compilation of documents for the convenience, that also
For the sake
shall
of
file.
convenience, when the matter was being taken up, we had actually caused service a paper compilation of all the records. Since
compilation is there, you have filed.
I had taken it, not filed it, kept it handy, so that if they do not file a paper book, so my compilation will be. I can serve my. I have already served my compilation.
Compilation includes those judgments and other
In
things.
everything, all the trial court
Apparently,
records,
they
I have
don't-
prepared them,
don't
handed
want a
over.
formal paper book as in a second appeal, but he has filed the compilation of
Compilation.
documents.
along
So you
with the along with the documents to be included in the paper book.
I have
Sir,
prepared.
Chaturvedi, in a second appeal, none of the documents are necessary.
No.
But they have
I-
filed a
ju-
compilation
No, the judgment decree they have included in their compilation, I suppose.
that they are saying. I don't know that they are
We have
saying.
handed over. Let them check that compilation index, and they can
That is
include.
served upon you, Mr. Chaturvedi. You have not seen that.
No, not yet.
I'll then.
Saying they have
Then
served.
I think we have prepared it, handed. We never handed it over. We have kept it.
They have prepared it.
We have prepared it.
Yes, you have not served them a
We have not
copy.
served because at that point of time, it was not being required because the application was being argued. So we had kept it
What
ready.
is the documents you have included in the compilation?
I have put all the trial court records, the plain judgment, decree, written statement, whatever available records of the trial court, I have marked it and put it across. I can give the index to them.
So you have annexed the judgments of both the courts below.
Yes.
You have annexed memorandum of appeal,
Yes.
order admitting appeal
Yes.
that you have made,
Yes.
and the evidences are also there.
No.
No. That was not there.
Evidences are not there.
No.
So can you make a compilation of the evidences since you have made all those? Though it's not required,
What I'll do is, Your Lordship, I am handing over a copy of the paper book. Let them see the index. Whatever is the relevant documents, they feel it, they can include it in a separate volume.
sir, I am asking you whether we have included the evidence.
Evidence is not included.
Please include that evidences. When can you make it ready? By Thursday?
By Thursday, I'll try. I'll
By
require Lordship.
Thursday, give a copy to them by Thursday. I'm keeping it on Friday for hearing Mr. Chaturvedi.
Only one thing, my lord. There is one application which is pending.
What application?
My lord, this application is with regard to the correction of the order dated 9th September 2025.
What is the correction?
My lord, there are, my lord,
September 2025.
my lord. But-
After that, Supreme Court has dismissed the SLP.
My lord,
That they are saying, I have not heard. So that's the order against which they have challenged. Supreme Court has dismissed that. Now, how can I correct? First, secondly, I cannot
Correction.
correct this.
correction is, my lord, is of the nature of a review. Even after dismissal of SLP, my lord,
So what's
Can
the
be-
review now you have
my
want?
lord, there are, my lord, some the corrections are though formal in nature, will not affect the final hearing of the appeal.
Yes.
But I am saying one of the days, my lord, kindly formally also dispose of that
I will
app.
take it up, Mr.
Yeah.
Chaturvedi. I will take it up the main matter.
Yes, my lord, I am only saying,
Fixing it on Friday.
yes. I'm not, my
What
lord,
what is the order which was passed on 9th of September?
my lord, 9th September, they, my lord, filed an application seeking, my lord, modification of the order whereby and whereunder, my lord, the conditions of stay and the order 41 rule 5 were imposed. They say that this should be enhanced. Such an application was dismissed. My lord, I indicate to my lord, there are formal defects in the order, like, my lord, it is, my lord, constitutional writ jurisdiction, the caption. Then the date, my lord, of the order, my lord, admitting the appeal. These are formal in nature. Hence, I'll say it will take only 30 seconds. But, my lord, pendency of the application, the appeal stands disposed of, would be an irregularity. I indicated to my lord's, my lord,
I
knowledge.
will consider.
Yes.
Start the argument of
Yes,
the
yes.
second appeal. I will consider that. That
Yes,
will
My
not
lord, I am the appellant, my lord. I am ready, my lord. Any day, my lord, fixes.
Friday. I'm keeping it.
Yes.
They will be serving this copy of the compilation by Thursday.
I have given the compilation. The evidences I am trying to collate. If I don't have, I'll take the assistance of my learned friend and I'll put that thing.
Or if you have the copies of those evidence, Mr. Chaturvedi, you can also prepare a compilation of the evidences.
Lord, I, my lord, need to, my lord, look into, my lord, the legible.
Alright, ask both of your learned advocates on record to sit together to see
That will-
whether there is anything, because no use multiplying, making two compilations.
No.
So if there is any deficit, please exchange those so that one of you who will prepare the compilation.
My learned friend has been, my lord,
You will
benevolent.
prepare the
I'll
other
prepare,
compilation.
I'll prepare the compilation. I'll just take the assistance only on the part of the evidences.
Ask your
Yes.
advocate record to cooperate.
My lord. My lord.
Ashok,
My lord, only one indulgence, my lord.
Mr. Bose is
My lord,
ready.
I am appear.
yes, Mr. Bose.
My lord, my lord, I didn't say anything. My lord, your lordship was pleased to fix it on Friday. My lord, instead of Friday,
Mr.
Well,
Bose,
can it
I
be
was
fixed?
thinking of fixing tomorrow.
very well, fix it tomorrow or Thursday, my lord. Even
But
Thursday is good.
provided you can bring those compilations, give them a copy in course of this day to the other side.
Very well, but order I was respectfully submitted by any day except Friday. If it could be Thursday or Monday or next
Monday.
Tuesday.
Thursday.
No, the only.
Sir, Chaturvedi, before you entered, I was telling your learned junior that more than a month, 3 months' time has been given by the Honorable Supreme Court to dispose of the appeal. More than a month has elapsed.
It has been brought to my lord's notice only yesterday.
That's a
Well,
different thing altogether.
My lord,
but,
doesn't matter, my lord, since it has come.
It has not been
Well,
said from the date of communication. It said within 3 months.
So
That
what if the order is not communicated to my
That's a
lord?
different thing altogether, Mr. Chaturvedi. But more
I'm-
than a month has elapsed. So
I'm only beseeching my lord, to grant me, my lord, only reasonable time so that I can collate the markings in my paper book along with the compilation, which, my lord, will be handed over to me, I suppose, today in the evening. So, my lord, kindly grant me only this much time that I can collate.
Thursday you are getting. They will be giving by today itself.
I have given everything, only the
But,
evidences. I
this-
need to sit with him.
My lord, the evidences, my lord, I understand this compilation cannot be, my lord, given to me, my lord, anytime before
Evidences,
tomorrow.
Mr. Chaturvedi, you have the copy.
I have the
The
copy.
copy of the evidences. You can rely on those. Don't only they will make a compilation annexing those. You can refer of the evidences of the respective parties. You did not refer to the page numbers. That much I will accommodate. No difficulty. You can prepare. You don't need to prepare from their compilation. You can prepare from your notes. Be ready with that. That minor accommodations can be made at the time of hearing.
Lord,
My lord, may I
kindly
just say
take
this,
me
my
for
lord?
my words, my lord, that I am prepared.
And
The matter
taking a
I do not,
conservative estimate how much time you will take.
Lord, I'll take a day, my lord. I'll take a day.
A day in a second appeal.
In a second.
How many substantial questions of law were framed?
Lord, I was about to address my lord on that.
Yes.
Lord, the order of admission, if
What
my
is the suit for?
lord, the suit
Eviction.
is eviction, only ground is, my lord, subletting.
Yes.
And
How many substantial questions of law and what is the substantial question of law?
Lord, kindly sees, Lord, the order of admission. It only says that
Please
the
tell me the,
yes. It will not only says that the appeal will be heard on ground number 3. So possibly, my lord, in view of, my lord, the recent pronouncements, will have to, my lord, frame further substantial question of
As per the ground number 3. Where is the ground number 3, Mr. Chaturvedi?
my lord. Lord, kindly, my lord, sees the paper book.
Paper book has been filed.
File करो ना. I'm so sorry. Lord, my lord has a memorandum of appeal. Lord, may I hand up my copy, my lord?
Cans have been disposed of.
Yes.
No,
Yes.
can, only one can, my lord, which I indicated to my lord.
What is the can?
Lord, that can is, my lord, can 10 of 2025.
Can
10.
in 9 disposed of.
Yes.
Yes.
That was our application.
तो can 10 तक होता है. Give me your copy.
My lord.
One of your copy of this.
Yeah, sir. Paper book your copy.
Yes.
My lord, kindly sees, my lord. I'm extremely sorry, my lord. Those would be marked in pencil.
No. Thank you. It will help me. It will help me.
My lord,
May go against you. Markings.
78.
Yes.
77 and 70.
my lord, kindly sees, my lord, ground number 3,
Yes.
whether the learned judge erred in law by not holding that the appellant was a tenant directly under the original owner and the lessee lease were granted to the plaintiff when the appellant was already occupying the suit premises as a tenant along with other occupier licensees, and as such the plaintiff cannot file a suit for eviction on the ground of subletting, particularly when prior to grant of lease, the appellant was a tenant under the owner. Now, this is
This has been couched in the form of a substantial question of law, not as a ground. So this is a substantial question of law. It was admitted on this.
it was admitted on this. Now, I beseech,
The only
I-
point, Mr.
no,
Chaturvedi,
my lord,
and
subject,
we will take an entire day for that.
my lord, subject to my lord's kind sanction. My lord, I would beseech my lord, to kindly, my lord, frame, my lord, a further question of law with regard to the competence of the plaintiff to institute the suit. This goes,
That's covered in ground number 3, Mr.
my lord, subject to my lord, kind pleasure.
Whether it's Mr. Chaturvedi, that's under ground number 3 or
Lord-
substantial question number 3.
My lord, whether the suit could have been filed because the plaintiff, the defendant, I'm sorry.
Simple argument of yours is at the relevant point of time when the appellant was inducted, there was a previous lease subsisting between the plaintiff and a third party.
My lord,
That's the only question.
now I say, I'm raising,
Whether on that the plaintiff had a right to file a suit for eviction.
no, I say that the admitted status of the plaintiff is that he's a tenant.
Yes.
Now, as a tenant, whether he could have filed a suit, whether the materials on record, my lord, they permit him to institute a suit against me, whether the proceeding is maintainable.
That is
to that,
covered under this ground number 3.
my lord, ground number 3 with deepest of respect, my lord, subject to my lord's kind sanction, my lord, I would, my lord, agitate before my lord, to invoke the proviso to, my lord, rule.
Mr. Chaturvedi, I'm aware of those that the court can at the time of final hearing
She shall make an argument, my lord, I would leave it to my lord's
frame
discretion.
questions. But the point which you are urging is covered under 3. That is why no use multiplying the grounds.
If I may,
Multiplying the grounds.
if I may, my lord, very briefly indicate, so that, my lord, if my lord is, my lord, of the pleasure to frame a question of law today, my lord would frame it so that, my lord, we come, my lord, prepared.
You start your argument. I will, if necessary, I will frame the question.
As my lord, please.
On that.
As
But as you have said, it prima facie appears that that is covered within ground number 3.
But kindly permit me, my lord, to raise this issue when, my lord, I commence my argument on the next day.
All right. And kota ground can tenta kota. Disposed of.
Yes.
এগুলো আবার লিস্টে আসছে কেন? This paper book. Mr. Chaturvedi, your client.
Yes, my lord, I take the responsibility.
No. I'm not saying anything. Have you filed this paper book?
No. This possibly has
You
not.
have a copy of the paper book. Please file it. Please file the paper book today.
My lord, it can be filed within an hour. It is in my advocate on records chamber. My lord, it will
So I'm
be.
recording that. Please ask your advocate on record to file it.
Kindly, my lord.
This matter was directed to appear under the heading 2. Mr. Chaturvedi, try to make it short.
No, I shall. I shall.
Issue is small.
I shall.
I
shall.
think there are a couple of judge decisions on this.
My lord, yes.
So you can bring those. Either of
Lord, can 10 be also listed, my lord? Subject to my lord's kind sanction, can 10.
can the
May I hand up to my lord?
Yes, what are the corrections? Where have you indicated?
Lord,
Only,
kindly cease.
may I indicate one thing, in all fairness, this, when we were filing the SLP, the CAN 10 was also made a part of the records and there was one ground of error. So that was also considered and disposed of. So I do not have an objection on the arithmetical error, but that was when the SLP was being disposed of, that CAN 10 was also before the Supreme Court.
Pointing out these defects.
Because we indicated that after filing this, that a CAN has also been filed to correct the anomalies. So that was also their part of the SLP record.
What are the corrections? Because
Lord, kindly cease.
Corrections are nominal in nature. I mean, these are all typographical errors. Like
Sir, Chaturvedi, will anything happen? Because the application has been disposed of.
I have not seen the Supreme Court's order, my lord. I do not know whether there is a conscious disposal of reference of.
No,
there is nothing conscious.
Mr. Chaturvedi, even if, according to you, the doctrine of merger will not apply.
My lord,
The revision
Bolo.
of review remains. I'm not on that.
my lord.
I'm only asking you because look, one against this Supreme Court has considered. They said that it was pointed out to the Honorable Supreme Court that a can was there. Will anything happen with what will happen? What are the corrections you want?
Lord,
Anything material?
Nothing is.
Why are you?
I'm only indicating, Lord, it's my
Because
duty.
this is, Mr. Chaturvedi, this is with regard to the occupation charges. Enhancement of occupation charges or modification of an earlier order relating to occupation charges or a condition of stay, whatever it might be. So some minor typographical errors, how it will matter?
I only, my lord,
Upon the
my lord, I say, I'm, my lord, prepared to address my lord on the merits of the case. As an officer of the court, it's my duty to indicate that an application is pending.
mistakes as I find
Yes,
some
date corrections, and my lord, kindly sees, my lord, page 8. But the
mistakes.
top head, spelling mistake, I am not, my lord, really concerned. Kindly sees top head at page 8. It's constitutional writ jurisdiction. Now, this and the date of admission, which is, my lord, 6 April 2005, has everywhere gone down as 6 April 2025. Now, I say this is formal in nature. My lord would dispose it of to only keep the record straight. As an officer of the court, I, my lord, indicated to my lord, I leave it to my lord's pleasure because this has got absolutely nothing to what I would address my lord.
Then let it appear, we will see. It has been submitted.
That's also pending since long.
That has not been, you are saying that all cans have been
No.
disposed of.
This is the only CAN.
I have no copy of that because I have not filed it and they have not filed it. They have not served copy.
It has been pointed out. Matter.
That is what I'm given to understand. That's an application for addition of party filed by another tenant. So that's why he did not serve a copy on me. I am not aware.
Who is the advocate on record?
Mr. Mehboob Rahman.
You can find him. You can serve a notice. Both of you can try and serve a notice.
He can. He's there in their premises.
No, I have no copy of the application, I say. It's not served on me.
I'll just
Your
indicate.
anxiety is to get the appeal.
I agree. I'll indicate.
Yes.
I'm deeply obliged to my lord.
Yes.
Agree.
The next matter.
My lord, in item number 2. in Item.
I am appearing,
item
my lord, on
number
behalf
2,
of the petitioner. My lord, my land,
completely at fault, my lord.
What happened?
since my lord, November 2023, my learned friend's client is at fault. Since November 2023, my lord, my learned friend's client is at fault, which is why,
What-
my lord, they were supposed to, my lord, put in the affidavit in opposition.
No,
Lord, the served
affidavit
the
in
copy.
opposition was.
They served a copy, did not, my lord, file it. When the term came, my lord, to file it, my lord, they said this has been misplaced. They will, my lord, reaffirm. My lord, that is also not being done, my lord, for months together.
What is the dispute in the writ petition?
My lord, my land, my lord, has been acquired, my lord, initially for the purpose of, my lord, setting up a satellite township.
Yes.
My lord, my lord, Asansol Durgapur Development Authority, my lord, Mr. Chatterjee is, my lord,
You are
representing.
Asansol Durgapur.
Yes. My lord, they were the requiring body.
Yes.
My lord, my land was acquired. Then,
Penalty for the state.
no, my lord, Eastern Coalfields Limited.
And for the Eastern Coalfield Limited, Lordship, I
Then, my
was the
lord, they
requisite.
dropped the idea, my lord, of, my lord, setting up the township. So, my lord, land was, my lord, to be, my lord, returned back, my lord, to me. That was not done. My lord, ECL, my lord, took possession of the land. My lord, started mining activities. My lord, there was, my lord, a memorandum of understanding kind of thing. My lord, coupled with,
Between you and ECL.
correct. And my lord, coupled with, my lord, other rules, my lord, regulations, and my lord, circulars, office memoranda issued by my lord, ECL, which provides that, my lord, in case of, my lord, acquisition of a land or user even, my lord, of a land, my lord, twofold compensation would be paid. One is, my lord, by way of, my lord, giving employment, and the other is, my lord, by way of, my lord, monetary compensation.
That was the memorandum of understanding.
The MOU, my lord, did not provide for that, but, my lord, there are office memoranda circular by which they are guided, which are, my lord, binding upon them.
Mr. Banerjee.
My lord, I will
Mr.
argue.
Banerjee,
My lord, I will argue.
Have you considered the recent decision of the Honorable Supreme Court passed in the last week? With regard
No,
to this?
that, my lord, I have not. My lord, I'll check. That, my lord, I have not. I'll check.
The issue which was.
But, my lord, similar matter, my lord, I have come across where, my lord, this has been held that, my lord, this is a twofold, my lord, compensation because, my lord,
That's why I'm pointing out.
oh,
last
my lord is pointing out, my lord,
question
yes, yes, my lord, I have just gone through the headline. I have gone through the headline, possibly Justice Pardiwala. My lord, is not coming back to my mind. I have gone through the headline in live law. Yes, my lord, it has come back, my lord, to my mind. I will go through that, my lord, I will address your lordship. But, my lord, they are standing in the way of,
I
my
have
lord,
not
this matter being taken up.
Seen that, Lordship. I will see it.
One Mr. Banerjee has seen, other Mr. Banerjee has not seen.
You know, nowadays those judgments will not pop up. So, Millard, it has become easier. But, Millard, kindly see, Millard, they are putting a spanner in the hearing even. Millard, I may win, I may lose, I do not, Millard.
Yes, Mr. Banerjee.
Since, Millard, 2nd November 2023, this is happening.
The affidavit in opposition.
Lordship, give me a week's time. Miss Sanchita Bormon Rai, Mrs. Miss Sanchita Bormon Rai is very terminally ill, and the officer who affirmed has left us. Now, issue, Lordship, here is the way he said that I have taken someone's land and started mining.
Mr. Banerjee,
It is not possible for a government company. No, that's what I'm saying.
To know what is
No,
the
why
scope of this
what I am
litigation.
saying, sir? Before I do any mining, I am under the DG Mines, Director General of Mines. Plan has to be sanctioned, land has to be
Statements from the
seen,
bar today.
That is
everything,
one way of
environmental
looking at it.
impact has to
today.
be
That
seen.
is one way of looking at it, and he is
Yes,
concerned,
nothing,
Those
no pleading
documents,
should have
those
before your
documents,
lordship.
which I,
concerned with his property.
those documents,
Take
Today,
can
Millard,
take
no
his
pleading
property,
is there. Millard,
provided
how
it
can my learned friend
compensates
argue
in
even?
accordance with the.
Lordship, those documents, since I could not lay my hand on those documents, we could not prepare.
Yes,
But that's not correct. Millard, that's not a correct statement. Millard, I'm sorry. Millard, there was an affidavit annex, Millard, documents are annexed to that was served upon us. Millard, these honorable courts deserve us. They should, Millard, reaffirm. It's not that, Millard, documents were not with them. It's not a correct statement.
Which order?
Last order.
Kindly, Millard, have a look at, Millard, the order passed
Last
on.
order, first
No,
order.
7th
No.
August 2025.
Lordship,
Then,
kindly see how they have done.
Uh,
The last order gave me the permission to file everything.
Millard, no,
Then
that
on the
was,
last
Millard, a
order,
wrong
they got
impression
it
was
modified
created.
orally.
Wrong impression
No,
was
no.
created, Millard, upon Millard, the honorable court.
time. So,
Lordship,
till your
Lordship, whatever steps I will take, I will take.
comply with this order of 4th September.
Lordship.
Not saying anything. Comply with this order of 4th September.
By a 10 days
The
time.
time
Yes,
is extended till next Monday.
Lordship. Lordship,
Milord, may it
Monday
be
and Tuesday,
preempted
I have,
this time, Milord.
Lordship, Monday and Tuesday I have a personal difficulty. Kindly make it up to Wednesday, Lordship, please.
You
Please,
may be in
Lordship.
personal difficulty. You will not draft the affidavit in opposition. You will settle the affidavit of
No, no, Lordship, nothing to be done. But
prepared.
she is not coming to till Tuesday. She can't attend court because her cataract also, and she had a very body sulfur burn, and all this has happened to Miss Sanchita Bowman Rai, Lordship. So kindly allow me till next Wednesday, Lordship. Just next day, Lordship.
Then you have to file the reply.
Milord, we are putting the reply since Milord.
Reply is there already.
Yes, because opposition was served.
Everything was done, only the copy.
They will only reaffirm it.
Yes.
No, along with supplementary affidavit in opposition,
Yes.
that is the order.
Yes, yes.
Milord is looking at the order of Milord
4th of
4th
September.
of September.
2025.
Yes.
Reaffirm and place the same within 3 weeks from date, along with supplementary affidavit.
Yes.
in
Milord, there was something, Milord, from them. I will just check.
So you don't need to file anything. Only they will reaffirm this.
Provided,
I
Milord,
will
they
use
give
this
us, Milord, what they have given us
Supplementary,
already.
I will
Provided.
He will use an exception to the
Says that
supplementary.
he has dealt with everything.
Provided, Milord, they do not,
Give
Milord,
him
annex
use
any new thing.
exception to the supplementary. Give him 3 days time formally so that he can do it or he can choose not to do it.
তো পুরো নাম লিখবেন না হলে আবার গন্ডগোল লাগবে মিস্টার সিদ্ধার্থ ব্যানার্জি লার্নেড অ্যাডভোকেট Yes.
My lord, I am praying not today, my lord.
I'm for
My lord,
secondary board.
well, I am for the petitioner, my lord, praying not today, my lord.
Ma'am, this has been assigned matter to
Yes,
be
your
mentioned.
lordship.
Why
My
are you
lord,
praying
I
for
have
not
to,
today?
my lord, I have to, my lord, talk to my lord, my petitioner, my lord, whether he, my lord, this is regarding, my lord, reinstatement of service. My lord, this is SSC matter, my lord. As per Supreme Court order, my lord, petitioner ought to get, my lord, his previous
This
service.
petitioner, your lordship, they are in-service candidates and they have lost their job by the order of the Supreme Court, your lordship. But there was a direction to reinstate these candidates, in-service candidates who are not tainted to their old service. So, my lord, that procedure has already started. From 7, this appointment letter has started being issued. So, my lord, whether this petitioner is within that zone or not, that instruction she has to take.
All right. So I'm keeping it. I'm keeping it in the next week.
Yes, your lordship.
Uh,
Thursday, 13th.
Thursday 13th.
13th.
It's not a Friday 13th.
Grateful, your lordship.
Yes.
My lord, I am for the petition.
For the secondary board, your lordship.
Yes. You are for the petitioner.
I am for the petitioner.
Yes.
The writ petition is challenging, my lord, the appointment of selection or nomination of the president of the managing
It's an
director.
assigned matter.
Assignment.
All parties are here.
My lord, probably the school authority.
To school.
No, no.
Oh, school is required.
What is required?
Appearance of school is required, your lordship.
Who is for the school? Anyone appeared?
My lord, Shubhra Prakash Lahiri.
He appeared. Yes, Mr. Lahiri appeared. So I'm keeping it in the Thursday.
My lord, kindly fix the matter any day after 18 because my learned advocate on record for medical treatment is
After 18th.
any day after 18 থেকে থাকবেন 18th হলেও হবে
20th.
Lordship.
Please করে দিন নামটা দিয়ে।
Yes.
If I put the petitioner lordship, but
আপনি আছেন রাজারাম? হ্যাঁ, লেখা আছে। ঠিক আছে। হ্যাঁ, অনলাইন।
for the petitioner lordship, this is regarding allotment of land lordship, and that has been grabbed by railway officials lordship. But unfortunately, I am not advocate on record. Advocate on record
He's coming, Lordship. I'm praying that.
But the arguing counsel, you can start. Yes.
But I don't have affidavit service on all that, Lordship.
All right. Who is the effective answering respondent?
Railway, Lordship.
My lord, I am appearing on behalf of a state, my lord.
You are appearing for the
State, my lord.
yes. 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 What is this?
And my allotment is, Lordship, annexed P1, Lordship.
P1.
Lordship.
Yes.
My lord, may I request one thing, my lord? Please keep this matter in next week. In the meantime, I will take the instruction from the competent authority, my lord.
Yes.
Now, annexed P1, my father's allotment, Lordship. And after my parents' death, Lordship, my father, mother, say annexed death certificate annexed, Lordship, both my parents. Now, Lordship, they are forcefully grabbing, Lordship, my property. I have made representation, Lordship. Page 27, Lordship. Dated 4th September 25.
So this property was allotted in your favor.
Lordship, my father's favor.
Yes. In favor of your father. Then what happened?
Then, Lordship, Railway's Lordship made a writ petition, preferred a writ petition before this Honorable Court, Lordship.
Yes.
Subsequently, there was an injunction order passed by this Honorable Court. And after formation of Lordship, the tribunal, Lordship, Land Reforms Tribunal, matter was transferred over there, and subsequently it got dismissed, Lordship, and order is annexed, Lordship.
Where is that?
Lordship. Page number, Lordship, P5, Lordship.
Page 26.
26, Lordship. Relevant page 26.
10 June. 10 June.
10 June 25, Lordship.
No.
10 June 25.
What was challenged before the tribunal? What was challenged before the tribunal?
Allotment, Lordship. The allotment, Lordship, was challenged before by the railway officials before this Honorable Court. That after formation of tribunal, Lordship, that matter has been relegated to Land Reforms Tribunal, and there, Lordship, after hearing, Lordship, and tribunal was pleased to dismiss this order, Lordship. And
Yes.
and injunction order was also vacated, Lordship. Now,
Yes.
Lordship, thereafter I made representation, Lordship, after death of my parents, Lordship, very next page 27, Lordship.
Yes.
But they did not, they are still grabbing my property, Lordship, forcefully and illegally. And those pages are annexed, Lordship, page 20, page 30, Lordship, page 30. P7, Lordship, annexed.
The representation.
Yes. Why we have not handed over the property till date?
Allow me 2 days to take the instruction from the authority, my lord.
Ashun.
This is not an.
The petitioner কি বললাম the learned that there was a Yes.
Hello, may I have affidavit, sir?
Court today is taken on
হাসপাতালে
it.
11
6 to 9, 7.
6 to 9, same. Yes.
I am for the 8, my lord.
I am for the private
I am
respondent.
for the 7.
Item number 8, my lord.
Item number 8 passed.
Yes, my lord. 6 to 8.
Mr. Rai, for whom?
of the petitioner.
Item number 8, you are also appearing.
All 6 to 9.
All, my lord.
6 to 9.
6 to 9.
6 to 9, all you are appearing.
Yes, my lord.
Item number.
Want 8 to be taken off
Yes, my
first.
lord.
In item number.
I am for 8.
For the private respondent, I have a preliminary objection.
Regarding the benefit of this, I know.
All right.
I am challenging the order.
In all the matters,
Are
in other
similar.
matters, he is not the private respondent.
Yes, my lord. He is the private respondent. All the
But
matters.
he is appearing only in 6.
Hey, all the matters.
You are appearing in all the matters as private
my lord,
respondent.
been instructed
to.
to appear in item number 6 only.
I am only instructed.
Party in the other writ petitions as well.
I am appearing on item number 7, 8, and 9
For the private
for the
respondent.
private respondent.
Yes, all of
Same parties.
Same parties.
Dada.
All right. 8 you want to be taken up, Mr. De?
Yes, my lord.
8 din.
8.
Until court.
I have some objection regarding maintainability of the writ petition.
Yes.
Raise that objection.
And is that objection? बोलूंगा क्यों ना?
Yes, what is the objection with regard to the
Where the benefit of this writ application, it is the order challenging the.
Yes, let him raise the point.
My
Yes.
lord,
Yes,
I am, my lord. I am ready. As because he is private respondent, my lord, I am state, I must raise.
This section.
My lord, your lordship will see that the order challenged by my learned friend, my lord, all the orders,
Which page?
that is page number, that is 31. Your lordship will see the order.
The last part.
Probably my learned senior friend failed to. It starts on page 29. Initial first order is page 29.
হ্যাঁ 29 কি আছে 29 এ
That is
Challenges from page 31. Relevant portion. Yes, so it is an order passed
by the
authority
district land and land defense officer.
54.
That is the appeal. Yes, my lord. That is the according to 2R. My lord, if your lordship will see, your lordship knows very well, my lord, all the things, my lord. According to 2R, 2, that is the West Bengal Land Reforms Act, my lord. That is a prescribed or specified.
Is a specified
Yeah,
act
a
under
specified
section
act.
2R.
Yes, my lord. According to 6B, my lord. Any order, inaction, or any action that is treated by the tribunal jurisdiction. And my lord, bar of jurisdiction, that is section 8. Bar of jurisdiction is this, my lord. They have not any right to come to the single bench. They have the right to go there according to
Against
the.
tribunal's order.
Yes, my lord, against the tribunal order. Yes, my lord. That is your
And
lordship knows.
exclusion of jurisdiction is section 7.
Yes, my lord. 7.
On and from the
8.
appointed date.
8.
that is
8.
not a-
Yes, my
8.
lord. 8, bar of jurisdiction. The High Court single bench has not any jurisdiction. Division bench has their jurisdiction, but he should touch the West Bengal Land Reforms Tenancy Tribunal, then come. Not in the order of the appellate authority, my lord. That is my contention, my lord.
Yes.
He must clarify
Yes,
all
Mr.
the
Raj.
things, my lord. to be-
it is
না ওইটাই বলো।
Can you turn to page 13? What is the order under challenge?
30.
13, 1-3.
Oh, 1-3.
1-3 ও ওই দুটো
1-3 is
that is the mala read
Prayer.
that is prayer
Oh,
prayer
prayer, yes. Certified the orders dated 2nd May 2024 and 28th of February 2025.
Now pause. Can you turn to page 29?
Yes.
I am agreed by the order which was allowing section 5 without giving me opportunity of hearing. And precisely, my lord, this
But
natural justice, violation of natural justice. It came of constitution before this. I'll rely upon Ashish Rai.
no. Mr. Rai, only one thing. Section 5 dismissal amounts to dismissal
No,
if section
it is allowing. Section 5 allowed expertise.
delay is condoned.
And this squarely came up for consideration before this honorable court, before the division bench as well as the single bench. And the alternative remedy is not ever in view of the violation of natural justice. This is violation of natural justice. Ashish Rai is squarely applicable. I'll deal with one by one, my lord. And this is the judgment reported in 2015 volume 1 CLJ
page 330, where the Honorable Division Bench was pleased to hold the similar facts and circumstances of the case. We are of the considered opinion that the appellate. Yes, I'm handing over to your lordship.
Only one copy, Mr. Rai, you are
In the morning, my lord, I get it for you, my lord.
All right, please. Which paragraph?
No.
Give me the reference. Give me the reference.
The paragraph নিয়ে এটা টানা ইয়ে করা আছে।
Ashish Rai, state versus Ashish Rai.
That is no.
That is the
No,
that's
that was
something.
considered in the
versus-
subsequent division bench judgment also.
Also, this is the effect of non-service of notice in allowing a section 5 by the appellate authority.
Right, there is no dispute.
And whether it is violation of natural justice or not.
Yes.
Apart from that, whether the tutor this is cartel by in view of the judgment derived Ashish Rai. What Malad Kali?
Yes, reference is
This is 2015 volume 1 CLJ page 330.
2015 1 CLJ
330.
330 paragraphs.
Malad, there is no paragraph mentioned. Malad, allow me to
Alright.
just give a small.
Yes.
We are of the considered opinion that the appellate authority ought not to have condoned the delay without giving any opportunity of hearing to the respondent in the appeal. These are three points over the. Now, my lord, the alternative remedy.
My lord, only for thing, my lord, this is not an alternative remedy. This is statutory, my lord, obligation.
So they
Restriction of statute.
exclusion of consider this. I will hear you. I will hear you. Yes.
Now, my lord, so the alternative remedy. After that, my lord, I'll draw your say Ashish Rai. This is reported in 1998 volume 1 CLJ page 500. Paragraph 3.
আর তো পেজটা বলো
500.
500
Paragraph 3.
Yes, my lord. It starts on the first at bottom. It is continuing regarding the. There also section 5 that concerning the same, my lord, allowed admitted the appeal. Admitted the revision application. Appellate authority admitted the same. Straightway come to this honorable court. It came up for consideration. Statutory way of an appeal.
Mr. Rai, with regard to this Gauri Shankar Chatterjee, now there what happened?
Just filed.
District Commission or at that point of time, the district forum
Forum.
passed an order. Against that, an appeal was carried to the state commission. State commission section 5 was allowed. Now,
Not
against
allowed.
the state
Without considering section 5, it is admitted.
yes, admitted. So virtually amounts to
National
allowing the
Commission,
section
if that
5.
be so, it is before the National Commission.
Virtually amounting to allowing the section 5. Now, against the state commission, there is no provision of second appeal. There is only a provision of revision, power of revision by the National Commission, not an appeal.
That came out squarely.
Now the question was whether 227 against an order of the state commission and a revisional power under the statute under National Commission, it has been held 227 can be invoked. It's not a question of alternative remedy. It was held that a revisional jurisdiction under the
I am on the analogy regarding if it is passed in violation of national justice. That is what.
No. That is one thing.
And here ultimately the conclusion is that
Mr. Rai, there is no quarrel to the proposition that without giving any opportunity of hearing, allowing a section 5 amounts to violation of the principles of natural justice. There is no quarrel to that proposition.
Now, apropos to
but
this,
the question is whether you can bypass.
Yes, that's why now I am
bypass.
Ashish Rai. Now I am placing Ashish Rai. 2005, volume 10, SCC, page 110. Paragraph 21, my lord, I am reading. After that, I hand over to your lordship. After analyzing the constitutional provision.
Please give me the reference.
2005, volume 10, SCC, page 110. After analyzing the constitutional provision.
110.
110. Paragraph 21. Paragraph 21. The constitutional bench of this court pointed out that the Article 323A and Clause 3D of Article 323B, to the extent they exclude totally the jurisdiction of the High Court and the Supreme Court under 26(7) and 32 of the Constitution were unconstitutional. The constitution of the said provisions was saved by well-known process of the reading down the provisions. This court held that while the jurisdiction of the High Court under 226-227 and that of the Supreme Court under 32 could not be totally excluded, it was yet constitutionally permissible for other courts and tribunals to perform a supplementary role. Can you consider? The Supreme Court said it is a supplementary role in discharging the powers conferred of the High Court and the Supreme Court by Article 226, 227 and 32 of the Constitution, respectively. Hence, it was held as long as the tribunal constituted to perform a supplementary role without exclusion of jurisdiction High Court under Article 226 and 27 and of the Supreme Court under Article 32 of the Constitution, the validity of the legislation constituting the such tribunal could not be doubted. It was in this circumstance that a direction was given that tribunals would act as the authorities of the first instance, whose decision could be challenged before the division bench of the High Court in this decision. Thus, constitutional bench of this court upheld Section 56 of the Administrative Tribunal Act as a valid constitutional interpreted the manner. So it is a supplement.
Yes, it's a supplementary role, and moreover, Mr. Rai, existence of an alternative efficacious remedy cannot be an absolute embargo upon the writ court to exercise powers under 226 and 227.
Precisely.
And under certain exceptional cases.
Now, what are the exceptional cases?
Cases of there where
yes,
even if there is an existence of an alternative efficacious remedy, courts can under Article 226.
Paragraph 25 of my writ application. If your lordship wants, I can produce all those judgments with that effect. I have called out the relevant portion.
Paragraph
25, page 10 of my writ application.
Yes, quoted Harbanslal Sahani.
Yes.
Yes, quoted from paragraph 7 of Harbanslal Sahani.
Yes, that is why
he will be getting you a chance.
That is his argument. That is our preliminary objection.
I will hear you, sir. I'm not.
That is what precisely I'm placing.
Paragraph
25.
Yes.
These are the three. One, any fundamental.
There is no dispute
so
with regard to.
I am on the II.
No, you are, yes, II. Failure of natural justice, courts can.
Not only that, everything was there, no notice, percentage, everything has been gone. Whether it is permissible or not.
Have you got L. Chandra Kumar, Mr.
That is relied upon in Ashish Rai. That's yes.
I have L. Chandra Kumar.
Then I'll bring it.
Because only one thing what is troubling Mr. Rai.
Bypassing the single bench jurisdiction of single bench. That is precisely.
Yes. because when the statute expressly bars
Yes.
the
That was considered. That is why the Ashish Rai came. Paragraph
because,
21, my lord, Kali Gorse.
in the judgment, the division bench judgment of Somir Kumar Sarkar, that was also before the division bench. That was also before the division bench. Division bench exercised the powers. Now the question would be, in view of that and L. Chandra Kumar, L. Chandra Kumar has specifically stated it's only the division bench which can.
Against the order. That is why precisely that was on that basis, my lord, the single bench.
Effectively, Mr. Rai, you are challenging that order. You have to challenge that order. So where? Whether you have to go relegated to the tribunal? Yes, you can approach the tribunal. There is no bar.
There is no bar. There is no bar.
in approaching the tribunal.
Whether I am precluded to challenge that.
Bypass, yes, whether you can bypass or approach the writ court. So,
L. Chandrakumar, my lord, that is why the L. Chandrakumar was considered and the single bench was pleased to held in this Ashish Rai that yes, that II is
Ashish Rai.
yes, your lordship find Ashish Rai is appealed by the state. Ashish Rai is appealed by the state subject to it.
Yes, appeal by the state.
Why three grounds are cited in Ashish Rai's case?
Ashish Rai was a division bench judgment here.
No, see, KJ Sengupta, as his lordship then was
division bench.
Subsequently,
There was a difference of opinion. Another division bench presided over by Justice Talukdar.
Yes.
So that conflicted with Ashish Rai.
Ashish
State
Rai.
versus
Yes.
Ashish Rai.
That is why it is the Honorable Appeals Court after considering the what
you
is
are right. Initially, the single bench. Thereafter, from the single bench order, there was an appeal carried by the division to the division bench by state.
State.
So that decision.
There is a
state
conflict.
Yes, state.
After the state went up to.
Thereafter, state went up to the Supreme Court in a further appeal. That's the difference.
That was the scope. That is why the scope was considered on what basis the Ashish Rai was honorable single judge and division bench is allowed. It takes away the right of a single bench under Article 226.
You have the division bench judgment of Ashish Rai.
That I have to bring because this is the judgment. I bring the Supreme Court judgment because the Honorable Appeals Court upheld the act on the ground that the tribunal is acting as a supplementary role.
Paragraph
21, your lordship find, is a supplementary role. Supplement cannot be take away the original power. As and when. If I am not wrong, my lord, your lordship will find this is the observation of the Honorable Apex Court. Tribunal is acting as
altogether. It was on the constitutionality.
yes, that is what
the tribunals would be performing a supplementary. So the act there is it cannot be said to be the provisions of the statute, excluding the jurisdiction of the High Court as well as the Supreme Court under Article 226.
And Section 8 was considered, Ashish Rai, my lord, from the beginning, my lord. What are the grounds the single judge was allowed?
But the only question is, Mr. Rai, that is troubling, is statute says
exclusion.
After that, it's the division bench. And L. Chandra Kumar also, I think in some of the paragraphs, I do not
that
exactly
is taken care of in Ashish Rai. That is also taken care of.
Yes, it says the division bench. Now, it's well settled, Mr. Rai, even if there is an
Keshavananda Bharati, after that is after Keshavananda Bharati, it is the basic principle 226, 226. That is the Supreme Court generally held.
Yes,
now the power exercise.
The power.
Now the power exercised by the division bench or the single bench.
Yes, that's
now my lord, can you process? If that be so, I am ready to argue on the what is the creation of division bench and single bench. Division bench appeal with the division bench is the creation of L. Chandra Kumar. That will come later, my lord. I am not on that. I'll whether 226 are exercised by High Court under Article 226, whether restriction can be imposed in the number of judges. That is why I said it is a supplementary proceedings, not the original proceedings. The tribunal is supplementing the workload of the High Court. And the object of the act, your lordship will find, the object is to reduce the workload from the High Court.
Yes, yes. Those
the-
are the objects.
Yes.
And the other way also, Mr. Rai, this is one line of decisions. The other line of decisions, you are well aware, it says that the court should be very slow. High court
Yes,
should be very slow because to
Now, my lord, privacy, whether a person, violation of natural justice cannot litigant who has suffered an injustice of appellate authority in his privacy right or their fundamental, as it, not the fundamental right, but the right to be heard in an adversarial litigation is curtailment of right to natural justice. Whether this can, a person can at all knock to the door of a high court under Article 226 or not. My lord can decide the same. Everything will.
yes, who will argue on the maintenance?
Private.
They will argue. Yes,
Sir, they,
yes, Mr. Dey.
না না আমি কে তোমাদের তোমরা প্রাইভেট রেসপন্ডেন্ট তোমরা যদি বলতে চাও
Raise your points because this will come in other matters as well.
একটু দাও land court.
section 8
My lord, if your lordship will come to us,
Land Reforms Act. You want
No.
me to see the
now.
Land Reforms and Tenancy Tribunal Act?
Yes, my
Why?
lord. Yes, my lord.
Yes.
My lord, my first point is that, my lord, that is not an alternative remedy. That is a statutory bar.
There is no dispute.
Yes, my lord.
There is no dispute.
Yes, my
There is
lord.
an alternative remedy. It is 2R Land Reforms Act, and also the order was passed by the appellate authority under section 54 against which an appeal lies.
Yes, my
There
lord.
are no disputes on that.
And
But what Mr. Wright tried to argue is accepting those propositions that is an appellable order and remedy lies before the tribunal. He's trying to make out a case that even the existence of an alternative remedy cannot be a bar. It's well settled under certain exceptional circumstances, one of which is violation of the principles of natural justice. And allowing an application under section 5 amounts to violation of the principles of natural justice. So why he should be asked to relegated to the tribunal, and he should not be allowed to approach this court when starting from Whirlpool there are series of judgments.
Yes, my lord.
which says that
Yes, my lord. That is
paragraph 7
under 4 exceptional circumstances, one of which is violation of the principles of natural justice. The writ court can be, the jurisdiction of the writ court can be invoked under certain circumstances. What is your answer to that? This is not in dispute. 2R appellable order, not in dispute.
And
so what is your reply to this submission?
that is jurisdiction also, my lord. That is the by statute, my lord. But jurisdictional bar was there, my lord. That is section 8. That is single bench has not any jurisdiction.
Mr. Dey, I'm accepting all those.
Yes, my
There's
lord.
the bar section 6, 7, 8. So this is the statutory remedy.
Yes, my lord.
Statutory remedy. But Mr. Dey, you are aware, even existence of those statutory alternative remedy is not an absolute bar in approaching the writ court. There are a line of decisions on this. But you have to satisfy those exceptional circumstances. You have to put your case within those exceptions. Mr. Rai is trying to bring his case within those exceptions. What is your answer to that?
That is
I'm not for a moment disputing that it's not an appellable order. There is a remedy. I'm not disputing those.
As because, my
Can
lord.
the High Court not entertain a writ petition wherein a section 5 application has been allowed without giving him an opportunity to of hearing, resulting in violation of the principles of natural justice? Whether in such a case also he has to go before the tribunal or he can approach the writ court.
My lord, according to his, that is Ashish Rai and others, my lord, that everything is, that it is very clear that there is a provision, my lord, statutory provision can't be violated by anybody. And that is, my lord, in jurisdictional point, my lord, that is the statutory bar.
Jurisdictional point. It's a jurisdictional point.
And that
Which
is
the root of the jurisdiction of the appellate authority.
and that was
take up the
the-
hearing of the
that was not challenged by the virus of that, was not challenged by that.
virus. Mr. Rai, Mr. They, not the virus. Allowing an application under section 5 without giving an opportunity goes to the root of the jurisdiction of the appellate authority to decide the appeal.
That is, my lord,
Jurisdictional error. Jurisdictional error, the High Courts under Article 226, 227 can look into. If you want some time, Mr. They,
yes, my
I
lord.
can give you a time because it's an issue which has to be considered.
Yes, my lord.
So straight away, I'm not minded to relegate him, but there is something I've seen from the decisions which Mr. Rai has shown. So I've seen those, but I want you also to work out on those.
So the court to
No, my
decide, my lord, whether, yes.
Lord,
So,
Bolo?
but I've
Bolo, bolo.
the
Lord,
decisions which
your lordship's permission, my lord,
yes,
and subject to
Now.
consent of Mr.
না না বলো বলো তুমি বলো
If I am not wrong, one of the objects of passing L. Chandrakumar's case was that the Honorable Supreme Court was flooded with the briefs from the Central Administrative Tribunal. And the Honorable,
only a decision.
because L. Chandrakumar's
says
case is
that 226, 227 is an absolute embargo.
I'm coming, my lord, I'm coming. Now, my lord, see, my lord, I can't recollect the exact nomenclature of the case. Where, my lord, it is from South India, one of the states, if I'm not wrong, it is from Andhra Pradesh. All the central government employees called a strike. So, the entire administration was at a stake. That was a time when the matter was taken straightway to this Honorable Supreme Court, and Honorable Supreme Court entertained the writ petition. My lord, ignoring the jurisdiction of the Central Administrative Tribunal. Why? Because all the employees, central government employees of that
So
state.
according to you, this is not an exceptional case.
No, is it really so that there is a grave emergency?
That is why I'm
in the matter. If no such emergency is there and a regular, of course, palpably, I am to agree with your lordship's view that when an application under section 5 has been allowed without giving me an opportunity of it is an abuse of jurisdiction. Instead of, I would, had it been drafted by me, I would have used that line that it's an abuse of jurisdiction. But my question is there really any grave emergency which should take your lordship to invoke my lord's jurisdiction under Article 226 of the Constitution of India, bypassing the jurisdiction under Section 10 of the West Bengal Land Reforms and Tenancy Tribunal Act? It's a 2 pages application, my lord, they will take up before the West Bengal Land Reforms and Tenancy Tribunal, and one day the matter will be disposed of. What? My lord, if necessary, my lord himself can pass that order. That liberty is given. What? That is the usual order now in Honorable Supreme Court. The liberty is given to agitate that point in a review application before the Honorable High Court. That is the usual order now before the Honorable Supreme Court. Now,
sir, don't say this. No. We are online. Don't say this.
I'm sorry.
Online, it's live streaming, please.
But now, what is, my lord, that if there is no such grave urgency, it's the only land dispute.
Want to cite any decisions?
My lord, in my view, my lord, they ought to have taken this application before the Honorable West Bengal Land Reforms and Tenancy Tribunal, because these.
Mr. Rai, where are those decisions where it says even if there is an alternative efficacious remedy under those exceptional circumstances, it can be.
That has been quoted. That has been quoted. Whirlpool subsequently
has been quoted in my lord Harbanslal Sahania.
And Harbanslal Sahania
has quoted
yes.
Although he has not mentioned Harbanslal Sahania.
Honorable Apex Court.
Paragraph 7, 3 points he has quoted. I was sitting there and checking. Absolutely, his junior has quoted.
I've said the Honorable Apex Court. These are the parameters based on which the court.
That is why, my lord.
One thing, what is troubling is whether it should be the single bench or the division bench.
That is precisely, that is the argument which regard to be held, whether the division bench, on what context, and single bench, because it is 226, 227, whether such class within a class. Now, my lord, I'll argue on that. Whether can be a class within a class.
No, but there are two things, Mr.
A division bench is exercising power under Article 226.
Yes.
And the
So
single
under
bench,
those ordinarily 226 and 227 are exercised by the single bench. Now, under those exceptional circumstances, 227 also before the division bench.
yes, that is on the basis of the judgment of the L. Chandra Kumar. That is the only, it is not the.
That is why I wanted to
That
see
is why,
Chandra Kumar.
yes,
That is why I wanted
because
to
Ashishai, those are considered.
quoted. But that
My
portion
lord is
has
now,
not been-
privacy, I have to satisfy your lordship. Yes, there is something in the my application for consideration.
Oh, you are
তো কি করবো?
before coming.
These judgments are there at least for side. That is without jurisdiction.
This is the
No,
reason why-
Ashish Rai, that is why Ashish Rai consider all the, because that is the preliminary objection taken by.
Mr. Dey, when you will can come with those
Next Monday, my lord.
next Monday?
Monday, Tuesday.
I will forget.
Oh,
That's the difficulty.
then my lord, Friday.
Friday তো
এই
second
Friday.
appeal টা fix করেছি।
কবে করবে? তোমরা বলো? Hmm. Private
No,
issue.
what Mr. Dey is submitting, you are telling me that it is in fact a private dispute between the
Yes.
parties over mutation of land, but
That's on merit. That's
my lord, the mutating authority is the statutory body. Their inaction has been challenged.
no,
in
that
an
he has
appeal.
challenged.
Oh, that is a.
That he has challenged, then appeal because he has followed the procedure up to the appellate
To
authority.
the appellate
Then
authority,
he is trying to
appellate
bypass
authority-
those remedies, whether that is permissible or not.
And that to be for the single bench. And that to be for the single bench.
too,
This is the only.
There are
consideration.
two issues. Even if I'm with him, that yes,
because
227 can be
even
then,
the
whether it
statute-
should be.
Even the statute, my lord, it has been mentioned, my lord, 11, section 11, appeal to lie to division bench of High Court.
That is why purposely, sir, I'm asking him that question. That is why.
That is why, my lord, the honorable single bench was
And
pleased to.
also,
Subsequent to that also, it came up for consideration. What is the effect?
also in the Administrative Tribunal Act, Mr.
Yes.
Rai, I have held it has to be moved before the division.
Division bench. That is why.
Uh,
But one argument which was advanced by
Mojumdar appeared. Somo Mojumdar
one
appeared.
argument which was advanced by.
Even 226, if I allow, that was the case where 227 was entertained. But my view was before the division bench.
I bow down to your lordship in view of the. There is a division bench.
That is so.
That squarely came up for consideration, and my lord, Mr. Mukherjee was. Mr. Mukherjee argued. Mr. Mukherjee argued that what is the effect of this division bench exercising power under Article 226? Under the Constitution, where is the provision? The allotment of roster and the judges, that will, I'll satisfy your lordship. There is no provision for single bench and division bench. That is what the.
You are absolutely right.
The
but
court
in a
exercising
case-
power under Article 226.
Otherwise, 7 except L. Chandra Kumar, you are right. But
That
you
is
see, L.
because-
Chandra Kumar has in one paragraph, I've quoted that in that decision.
That is why, my lord, the honorable single judge of this court
That is why-
was pleased to held that no, it take away the right of 226. Supreme Court considered, and it is,
There are two things. Whether it should be relegated to the tribunal or 226.
yes.
Even if you succeed on that,
Then all
then the
single bench
question
or
is-
division bench.
Then-
And this first thing, my lord, allow me to overcome that whether I can knock the door of 226. Single division will come later, whether that can be permissible.
that answer will be in the judgment, final judgment.
No, at present, my lord, that is what, my lord, at present.
Yes, at
Today is
present-
the date fixed for correction.
Okay.
Probably
That-
my understanding.
Yes. Mr. The interim order has to be passed on that.
Yes, my lord. That is
Uh,
not the issue.
Correct.
ইচ্ছে করে পরিচিত অন্য কিছু না, এটা ইচ্ছে করে করা আমার।
Yes. Yes, yes. What a good service, Mr. Ghosh. Addressee cannot be located. Can it be a good service?
My lord, I have got instruction, the land is vested to the state, but patta has been given to the private respondent.
Patta has been given.
Already patta has been given.
No, Mr. Ghosh, if the patta has been granted, so cancellation you have to take other recourse.
Using as a road. Alai road is there. Now one of the house and the area of the total land is 61 decibel. But from the one of the website it appears that the patta has been granted in respect of 8 decimals only. How one of the kindly guided the state to submit the report? How one of the on the road, one of the patta has been granted and physical inspection is required. Some extent I have received from photograph. My client send a photograph where from it appears this is Dhalai road.
What right of yours is affected?
My right one of the
Ingress and egress.
yes, adjacent to my that is my IIT plot. I have and it's not yes,
It's a government road.
page 48 kindly comes to Soripur Islam.
Government of belong to PWD Roads Department, Dhalai.
78.
So your property is 278.
78.
Government road is 231.
231.
231.
231.
So on 231, these constructions, according to you, have come up.
Yes.
And
I'm one of the for removal of that. I approach one of the
Mr. Mahato, 231. Whether you have granted patta in respect of 231 or some other plot.
In respect of 231, patta has been granted, but
So in the
I
Moja
have
map,
not- I have
in the
not
Moja
got-
map, how it has been shown plot number 231, and in the record of rights, how it has been shown 231. What's the classification?
It is vested land to the government.
It's not a road. He says it's a road. If it is a road, can you grant patta?
I have not got the patta, but let it be day after tomorrow. I will got the patta. I will produce the patta. I have
First, you have to specify what is the nature of this plot 231 from the record of rights and the Moja map. If it is a government road, Mr. Mahato, you cannot. Road, you cannot grant patta.
In road, patta cannot be granted. If it is granted, then
That's the specific allegation in the writ petition.
kindly see the allegation is my lord. Kindly see the allegation is page 51. Only
51.
Page 51 only representation.
Yes.
জোরপূর্বক দখল করে তারপর পাকা বাড়ি নির্মাণ করিয়াছে। Here it is my lord the past tense.
Yes. নির্মাণ করিয়াছে। Where you are reading?
On that
Yes.
PWD.
PWD roads. PWD roads. So here also he is saying it's a property of PWD roads means it's a road. Not it's a layman's
But
representation.
petitioner has not produced any document or record of right.
But you show that.
What I am saying, I have made the representation. It will be in the record of right. It is showing body classification of the
Body.
Then I have gone.
Classification is
Body or homestead. But my lord, physically. There is a road is that and my lord, without any proof, without any document, physical inspection. That is one of the record of rights is one of the scientific that is divided. But what is other documents you have placed?
But Mr. Ghosh, can that be decided here?
Can be decided.
Whether the record of rights, those recording
record of rights
was
not create right.
or not.
Whether this plot is using as a road or not, that can on the state can one of the asset and bank.
If it is home and
Now the report of they one of the total plot of the subject land is 61 decimal. Out of that, 8 decimal.
What is this document at page 49?
Page 49 of the page 55 malad.
Sorry, page 50.
Page 55 malad kindly comes to in response to my application malad the authority director
No, no, page 50. Where have you got this page 50? Yes, there's a sketch map.
Yes, yes, that is a from the Moja map. It's a portion of the Moja.
Yes, Mr. Mahato, please see page 50. 231 is the disputed plot. Disputed plot is Sarkari Rasta. From your Moja map, it is showing.
Now, kindly come to page 55. They have
You have seen. This is from, he says, from the your Moja map. It shows that it's a Sarkari Rasta.
Entire plot is showing Rasta.
Yes, from your Moja map.
This is the
Your
Moja map.
document.
This is the Moja map of LR.
Yes.
LR Motab.
So how, so now presently it's Rasta. So how construction has to be after that? How can you grant patta? Your statement is that patta was granted. How could you grant patta on this Sarkari Rasta?
It could not be. If it is Sarkari Rasta, I have to take
Yes,
detailed
please take instructions on this. Please take instructions on this. Petitioner claims to Name of the advocate is also same.
No, I mean,
Same order. You are
I
appearing.
am not appearing in this matter.
Who is appearing? All of you are here. Any one of you will appear.
You will appear.
You appear same matter, so I
Same
just
matter.
here. Mr. Ghosh, have you served upon the state? আচ্ছা তাহলে একটা লাইন লিখে দিন Yes. 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 What do you want? Allegation of encroachment. Yes, Mr. Dhar. Consider this.
Yes, yes.
Who will consider?
Kindly check my lord whether I'm not too sure.
What?
Private respondents.
You are the best person, Mr. Dhar, to know the address of the private respondents. When you go there to demarcate, they will come to you.
No,
So-
I was telling Mr. Ghosh, made a request that even notice would be served through WhatsApp. That is a valid note. These people they intentionally avoid.
That's a different thing altogether. WhatsApp now, the Honorable Supreme Court is not approving that. Saying should not be done. Not WhatsApp, also email.
That is also not valid.
In one of the orders I have seen. That was not accepted as a
What
valid.
about the IT Act then? What about the Information Technology Act?
That I do not know. You raised that issue there. Yes, where is the representation? 1-6.
After filing the
Demarcate.
Yes.
When?
Kindly direct the concerned BLLRO to, because as per the instruction which I have received, that they have passed on the message to the BLLRO and requested the BLLRO to demarcate.
So what is the BLO doing from April to November? At that time, SIR was not there.
Yes, now SIR,
Yes.
now they
So
will be.
now you will take the plea of SIR, then election. What he was doing from April to November?
Let me use my good office.
Thank you. Ashwin. The yes, what is your allegation? Yes, encroachment. What difficulty you are facing to the PWD road? What is your plot number? Paragraph? LR tag number 75. 368. You are the sole owner or you are the co-owners? Sole owner. The petitioners claim to be the joint owners Yes.
Same matter, my lord.
Same, more or less same.
Okay, so in front of my house, the government note has been pressed.
My lord, Gaurav Das is appearing on behalf of the state, my lord.
Who is appearing?
Gaurav Das, my lord.
Yes, yes.
My lord, due to his personal difficulty, could not come to the court, my
You
lord.
are here.
But I am the not in panel, my lord.
You are not in the panel.
No, my lord. Pay for 1 day accommodation.
Just going to see my notification, we received the same, but they are taking steps, they are causing prejudice to my rights being
Yes.
Only 1 day accommodation, my lord.
An accommodation, heard the learned advocate for the every service filed in court today is taken on record. The respondents have been duly served. Right. Respondent, Lord, I have got the report.
Grievances of the petitioner has been redressed, Lord. He has got
The petitioner.
I'm not, I'm respondent number 7, private. Perhaps petitioner will not appear because the redress of the petitioner has been redressed. Grievances of the petitioner has been redressed, Lord. His work order in favor of him already. I think.
Work order.
Yeah.
My lord,
Your Lordship, kindly see that.
in respect of a tender for collection
Being
of
the
toll-
highest bidder, Lord, his work order has been issued in favor of him.
Yes,
I have
yes.
just handed over the report, Lord. Your Lordship, kindly
He's
see
in,
that.
he's in what? And only that I am appearing for the responsibility. There are so many allegations against.
There are
So many allegations against the
you have not challenged this.
No, no.
You
This
take
is not the
steps.
subject matter of challenge.
I am not.
This is not the subject matter of challenge.
Allegations in the petition is not acceptable.
All right. That
Only to that.
none appears for the petitioner at the time of call.
But I beg to appear on behalf of the
Lands of
state.
the petitioner have been used by constructing road. No acquisition process was initiated, no notice was served, no.
My lord, it's a road.
investigation has been.
Let him finish, my lord.
My lord, under the supervision of the my lord SDO of the territorial jurisdiction, my lord constructed, my lord, it has been converted into metal road. My lord,
Converted.
Converted into my lord metal road. Firstly, Kacha road, thereafter
Yes,
metal.
What is your instruction?
My lord, so far as my instruction is concerned, my lord, the road is constructed under the scheme Pradhan Mantri Gram Sadak Yojana.
Whose property have you utilized?
I am representing the state, my lord.
Whose property have you utilized for the
My
purpose?
lord, there is no provision so far as this scheme is concerned. There is no provision for providing compensation, my lord. And kindly peruse the instruction.
Private
This
property
is
you
the
have
file.
used.
This is not the construction. This is not the construction. There is an existing road. We are only engaged to
Sir,
for the purpose of the
plots
maintenance of the.
Which plots you have utilized for the purpose of construction of road under that scheme? Does your report indicate that?
There was an existing
Mr.
road.
Chatterjee, I am asking you, does your report indicate
No,
which
there is
plots?
there is no
Please
indication.
file a report stating which plots
Yes,
were
my lord.
utilized for the purpose of
Yes.
constructing the
Yes,
road.
my lord.
Ashun. Every service taken on record. Yes, next.
Leave is granted, my lord, correctly. To add him.
Yes, yes. I've given leave.
Yes.
16 minute, I am appearing for the petitioner. File these.
Petitioner.
Petitioner. No, I mean,
Yes.
The petitioner is an owner of a three-storied house at Pachla, Howrah. Now in 2011, my lord, the Howrah Rural Administration, this is a police, my lord, under the Howrah administration, they occupied, my lord, almost 80% of that house. No permission, nothing. They simply occupied.
Who occupied?
The Howrah District Rural SP office, SP administration, superintendent
Property
of
is
police.
owned by you.
Yes.
How did they enter?
My lord, I'm coming to that. How they then, my lord, the superintendent of police, rural district Howrah, sought for a permission. In 2012, my lord,
permission from you,
from the director general. Now, in 2012, by a memo, I'm showing that, my lord, the director general, my lord, granted permission. Kindly consider that. Then, my lord, I shall make further submission. Kindly consider page 28. My lord, this is a letter dated at the end of the page. Your lordship will find the date 7th February 2012. Page 28, 7th February 2012. This is the date of the this letter at the end of. Then issued by the Director General, Inspector General of Police, addressed to the Deputy Secretary to the Government of West Bengal Home Police Department. Subject: proposal for permission for hiring premises for proposed office of Superintendent of Police, Howrah Rural District and Howrah Rural District Police Lines at Paniara under Pachla PS District, Howrah. Then kindly consider, this is very important, reference. This office memo dated 27 July 2011, my lord. So a reference by, a memo was issued sometime on 27 July 2011. The office
your
of
property is which one? Milan Biti or Alisha?
No, Alisha. 5 and
Alisha,
6.
ground floor, first floor and second floor.
Yes.
So you are 5 and 6.
5 and 6, right.
No, how did they enter into possession? What's the understanding?
My lord, I'm coming to that, my lord. Your lordship, kindly consider an agreement which was executed at page 32. I'm sorry, at page 30. 30, my lord. Kindly consider, my lord, the date of the agreement, 23rd February in the year 2017. Between the petitioner, Sheikh Sadiq Rahman, and, my lord, kindly consider the second page, page 31, Superintendent of Police. Now, my lord, kindly consider the third paragraph. And whereas the first party...
Third paragraph, 20th of July 2011.
Yes. Then, my lord, your lordship, kindly consider page 32, the first paragraph, that the agreement will remain valid for a period of 10 years, commencing from, then handwritten it was incorporated, 1st September 2011 to 31st August 2021, and mandatorily renew the agreement after 10 years between the parties. These were all drafted by the police authority. They just obtained my signature. Now, this was executed on 1st of March 2017. Now, it expired, my lord, on 31st of August 2021. Now, so far my lord, rent is concerned, my lord, I raised an issue that I am not getting proper rent, my lord, fixed by the state of West Bengal. State of West Bengal, my lord, by different memos, my lord, fixed this rate where, my lord, they take and hire, my lord, go for an hiring on the basis of, my lord, this public premises, or not a public premises, private premises. Now, one of such, my lord, memorandum is at page 63. This is, my lord, slightly illegible, my lord. The last paragraph.
What relief you are claiming?
My lord, I moved a writ petition. Then, my lord, this issue was referred to the Superintendent of Police, my lord, to consideration, since I am not paying proper rent. The Superintendent of Police, my lord, at page 67, my lord, admitted that they made several proposals, my lord, to release my payments. That has not been done. Till date, my lord, I am, my lord, getting the old rates, your lordship.
So now your grievance is not with regard to the fixation of the rate.
One is, my lord, fixation of the rate. Second is, my lord, on...
Are you, there are two things. Are you challenging this order with, what is the fixation made?
My lord, they have fixed, my lord, page 67 is the impugned order.
Yes.
Now,
Where is the fixation made?
my lord, from paragraph 8 onwards, my lord, at page 68.
Yes.
On 23rd September 2024, a reminder was sent to IGP West Bengal for sanction of enhanced house rent of Alisha Complex ground with effect from 1st of September 2019. Kindly consider payment of Alisha dated 17 July. Accordingly, assessment was done by the land acquisition collector.
So it was made 91,261 with effect from 1st of September 2019.
Correct. Then it was further enhanced, my lord. Your lordship will find paragraph 11.
Yes.
As
Paragraph
per
11
memo,
was further enhancement with effect from 1st of September 2024.
correct.
Yes.
Then
So
one
now, is it your case that these two fixations are not right?
No. First,
or according to you, you are not getting this amount?
I'm not getting this. Secondly, my lord, during this hearing, my lord, I asked for this memorandum, my lord, those, on the basis of which, my lord, they arrived at this calculation. Those were not handed over
Which
to
memorandum?
me. My lord,
This
there are,
1160 dated 11/8/2023.
yes, this is
And
one.
another is
Another
5th
is,
of
my lord,
November
paragraph
2024.
11, 1168 LAG dated 5th November 2024. These two memorandum, paragraph 11, on the basis of which rent was fixed on the basis of at rupees 1,14,077. Paragraph 11, kindly consider. Memo, my lord, issued by the land acquisition collector, Howrah.
But your claim was wide memo dated 11/11/2024.
No, my lord, I was getting, my lord, only
Please kindly come to paragraph 12.
Yes, during personal hearing, the petitioner submitted a letter dated 6 November 2024, along with his annexation. Same has been forwarded to the land acquisition collector Howrah to ascertain the feasibility for the enhanced rate of the claim by the petitioner subjected to the government rules. Vide memo number 11th November 2024, and the decision is awaited. Then, in the backdrop of the above stated facts, it is decided that the enhanced monthly rate would be paid to the petitioner.
What is the amount which you are now getting?
76,000.
For the entire?
Even today, my lord, this 76,000 was fixed sometime in 2018.
It's
for the entire.
Ground, first and second.
And my lord, they have now also occupied the roof. That has.
So, Mr. De, your assessment you have to pay. So how soon can you pay this amount as per this assessment? It's your assessment, you have not challenged. So how soon can you pay the deficit?
Well, if you are whatever your time you will fix, my lord, that is.
I'm asking you, Mr. De, that is why. What will be the amount, Mr. Rai Mukherjee, as per your calculation, the deficit as per this rate?
My lord, it will be around 60 to 70 lakhs. And that too, my lord, I am, my lord, also disputing this. That, my lord, yes.
Get this.
Yes.
Sir, after the whether you will be entitled to further or not, that can be considered.
Absolutely.
First, see the color of the.
Yes.
Yes, Mr. De, how soon can you pay this? Because you have got an his estimate maybe somewhere here or there, maybe some calculation errors and.
Position, that is whatever our calculation is there, my lord, that is calculated by the
collector
according to their memo, my lord. Admitted position, your lordship can fix the time, admitted position of the, you will get that.
So 4 weeks, 4 weeks deposit the entire, pay the entire amount, balance amount.
According to the admitted position.
According to this, I'm keeping this pending. Second is, what is your decision on paragraph 12 of this order? Because you have said the decision is awaited. So take this decision.
In the backdrop of the above stated, decided.
So paragraph 12, page 68.
Yes, my lord, I have read that.
So you have said that the decision is awaited.
Our next way, the backdrop of the above stated, you decide enhance now present to be paid to the picture on getting the approval of sanction of funds from the higher authority of the matter.
Yes, new agreement they will enter into. Mr. De, there are two things. New agreement they can enter into, but the question is, there are two issues. One is paragraph 12. So paragraph 12 says.
Well, but my lord, next page also.
No, I'm coming to that. Paragraph 12, they have given a letter for further enhancement. One is this amount, one is they have said we want further enhancement. That was sent to the concerned authority. Decision is awaited. communicate him the decision, whether you have rejected that prayer or you have further enhanced it. So that has to be done within a time. Second is with regard to the areas that you have said that with the approval of the sanction of funds. So I'm giving you time limit. Within that, the highest authority or the higher authority that has to sanction and pay it. So I will give a consolidated time limit within which sanction everything, including release, has to be made. Sanction is your headache, but here new agreement. But prior to the new agreement, the rate is to be finalized. Unless this decision is taken, how soon can you communicate to him this decision? Paragraph 12.
Give me 6 weeks time, my lord.
By 6 weeks. I'm not on the payment decision, whether you have enhanced or you have rejected. This was in what is the date of this order?
My lord, this is dated
19th of November.
19th November 2024.
More than 1 year, and you have still not communicate decision
For,
within
my
a
lord,
year.
for that issue, my lord, 6 weeks. Give me.
1 week communicate the decision. For payment, I will give you time. 1 week communicate the decision is 1 year back.
From the date of servicing notice.
Receipt
From
of the
order.
server copy.
Yes.
Let him communicate the
Very well.
decision,
Very
and you do one thing. Let him communicate the decision. You give your calculation to Mr. Day.
Very
Within this time, as per this rate.
well.
And after a week, I am keeping this. Get that, so that, and because you have to also enter into an agreement.
My lord,
Prior to that, the rate.
subject to the conditions, my lord, to be given by the police
That
authority, my lord. If
Our
they
rules, my
stick
lord.
to this old rates, my lord, then
No. That not the old rate. Now the rates have increased.
Yes.
Now whether it will be further increased or not, that is subject
My
to the
lord,
subject to
paragraph 12.
correct.
So paragraph 12, let them communicate.
My lord.
So by then the rate can be finalized.
Very well. Very
Rate
well.
can be finalized, and the balance amount you give your calculation so far as this rate.
Very well.
If it is rejected, then that rate will be final. If it is increased, some more additional amount will be there. That can be directed to be
Fine.
paid in installments, and that final rate will be the agreemental rate.
Very well.
The petitioner
At the time of drafting, when I said that you are also entitled to get interest, may I ask it? He said, no, because my religion does not permit to ask for interest. I said, very well, it's your business.
After all, you are the creator
Yes,
of instructions.
yes.
You can look, Mr. Day, he is not also claiming interest.
Not ask for interest, my lord.
My lord,
Please consider
I
that.
know the actual position of the my lord, that those geo my lord.
Unbelievable.
That
my
is
lord.
why
Now it is.
Our officer has not any right to
No, I'm
deviate
saying
from
these
that.
are my lord, rare persons, man.
has to be, but make him understand because the petitioner is not claiming interest. That is what
It was
he is
my
submitting.
specific instruction,
Yes, well.
not to my lord
Spite of his
incorporate such
instructions,
prayers.
please also you have to keep that in mind.
I must, my lord, I must try my level best, man.
I'm grateful, my lord.
Thank you.
Excellent.
I'm for the petitioner, my lord.
Yes.
Lord, the matter is about, my lord, the private respondent is disturbing my position of the ingress and egress, my lord. They have made construction over the PW land by constructing a tin shaded room, my lord. So we have made representations before the concerned authority. And earlier occasion, my lord, we have also preferred an writ petition. And on that writ petition, it was directed to remove the illegal encroachment over the said property, my lord.
Where is that?
But it is at page 49, my lord. Starting from 48 to 52, my lord.
What happened after this?
After this, my lord, they have not removed the said construction.
No, there was a direction to consider
Lordship.
any decision order has
No,
been
lordship.
passed.
Lordship, no, nothing. So we made representation, my lord,
He
before the
lies to
concerned
file a
authority, my lord.
contempt application.
No, my lord.
The direction has not been complied
Another
with.
person made the construction. Thereafter, another person was made construction at that time, my lord. And in this writ petition, the private respondent has made this construction, my lord.
So this was the
And we have also made representation before the concerned authority to remove all the said illegal encroachment, my lord.
where is that representation?
Is that P3, page 46.
Page 46.
Lordship. 46 and 47.
You have the State Highways Act.
No, Lordship. No.
1960. Yes, you are appearing to the state.
17.
No, my lord. Respond number 11, private respond.
Yes, what is your instruction?
I have never encroached my client, my lord.
Lordship kindly goes through the photographs once, my lord.
I am appearing on respondent number 11 only, private respondent.
Who is appearing for the state? Have you served upon the state?
Lordship, I have served.
When they have received?
On 8th May, my lord. This is
On?
affidavit of service. 8th May, Lordship.
8th May.
Lordship. This is my affidavit of service, Lordship. Kindly goes. And without taking any permission, my lord, they have made this construction and no removal order has been passed by the concerned authority, my lord. As per section 10, I am not carrying the here at right now.
The earlier occasion, the writ petition
Lordship.
was against whom? Who are the private respondents there?
One Shukurali.
That was with regard to which plot?
Plot number, my lord, it has mentioned.
Petitioner claims to be Yes.
My lord,
I am for the private respondent on second.
my lord, initially my grievance was, my lord, private respondent constructed, my lord, the shop rooms on the PWD land in front of my property and blocked my regress and ingress. My lord, then, my lord, I moved on writ petition, and Honorable Justice Aniruddha Rai directed to consider my representation. As per order of this Honorable Court, my lord, assistant engineer started proceeding. That is, my lord, page 33, kindly see. Page 33.
Yes.
My lord, last paragraph, my lord. The private respondents also admitted in their verbal deposition that they have constructed unauthorized structures on PWD land in front of above mentioned ports, and also said structure does not create any barrier of his ingress egress. I have thoroughly heard the respective parties present today and seen their respective documents in support of their claims. It may be clear that the private respondent occupied government land in question in front of the petitioner Rayat plot in an unauthorized manner. Now it is necessary to demarcate the encroached land in the field. My lord, then, my lord, BLRO, my lord, demarcate, and my lord, kindly see first, my lord, page 46 and 47.
Yes.
My kindly see first, my lord, page 47. Unknown name, acquired area square feet. Sujoy Mondal, gents parlor, acquired area. Onil Coil, automobile shop, acquired area. That is there. But, my lord, kindly see page 46. The sketch map.
Yes.
My lord, Amin Road, my lord, existing PWD road.
Yes.
That means pitch top road, I think, my lord.
Yes.
But 1, 2, 3, 4, 5, 6, that subrooms out of existing PWD roads. But PWD acquired area, my lord, he has not mentioned. That is why, my lord, kindly see for a moment, my lord, page 50. To 50. 51 out of it. That is last page, my lord. That is when a local Amin, my lord, PWD area. Page, last page, my lord, 51.
Should be 51.
51, but the wrote as 50, my lord, wrongly.
Yes.
My lord, that sketch map is, my lord, drawn by another man. My lord, that should be PWD area, existing PWD road, my lord. That means pitch top road. And, my lord, out of that PWD area, there are subrooms constructed there. But assistant engineer is saying, no, there is no clear picture in the sketch map. That is why I cannot take any steps against the private respondent.
No, this is page 51 has been prepared by whom?
By local Amin, my lord.
By local Amin.
Yes, my lord. But that is, my lord, for my understanding, my lord, that is prepared. But, my lord, BLRO, Amin of the BLRO office, that means 46, my lord, page, he has that sketch map drawn by the Amin BLR office, page 46.
Yes.
Yes, Mr. Mahathir,
My lord,
please say.
in the contempt application, my lord, this point was taken. For violation of
Contempt application says that because the scope of the contempt is limited.
contempt is for violation of the
Limited.
order.
For violation, it has said that it has been done. Now, with regard to the correctness, what is your instruction with regard to page 51?
My lord, page 51, it is, my lord, it has not been, my lord, forwarded to the BLR or otherwise. It is the, my lord, the private.
Yes, yes. It's a private, which has.
My lord, let there be direction to the BLR to compare with the, my lord, the earlier, that is page 46.
That should be clear, my lord, PWD area, total PWD area.
Because Please kindly come to page 47.
My lord.
47 acquired area has been
My lord,
said by the revenue inspector also.
my lord.
My lord.
So acquired area of which portion? It has to be a PWD area. Page 47.
Page 47, yes.
So,
But that is not the roads area.
may not be roads, PWD area.
My lord, yes, PWD
Can it be
sometime,
encroached?
my lord, PWD sometime keeps its
That is why you can also widen the road.
widen for widen.
Yes.
Let it be, let it be, my lord, considered.
My lord, nobody construct on the PG top road, my lord.
And a plot number, my lord, it is a pukur. Classification is pukur. That
Which plot number is pukur?
805. That is the subject matter of the case. Well, several sub room was there. Several.
805 is a pukur.
Yes.
So you have constructed on the pukur.
You have not constructed.
Who has constructed?
They constructed the pukur. They are saying egress or ingress.
No. Where is your shop room?
Sub room on the PW road. Several sub room, my lord.
On the PWD road.
My
I don't know, my lord. Several, man.
No. Please be specific. Whether your construction is on the PWD road
No.
or by filling up the
PW
water
road.
body.
No, my lord.
Which dark number you have constructed?
That number 805 is a 50 decimal land. 50 decimal land.
It's a water body. 50 decibels is a
Yes,
water body.
That water is a filled up.
And you have filled up. Who has filled up?
That I don't know, my lord.
And you have constructed on 805?
Oh, 805, my lord, not PW.
So please excavate the water body. Whoever is there, remove everyone.
My lord, my lord.
My lord. Filled up, my lord, it should be.
My lord.
My lord, yes. Second time, my lord, that petitioner is a title suit easy. Petitioner is a
title suit, you fight it amongst yourselves with the title.
Yes, my lord, title suit. Well, I am citing a judgment.
Concerned with the title suit.
Well, kindly see,
You
I am.
cannot encroach a PWD area. You cannot construct by filling up a water body.
During the pendency, petitioner purchased the property. Already title suit is pending against the petitioner.
No, and if petitioner has constructed on the water body
My lord,
or
my
on
lord.
the PWD area, that also will be
I
demolished.
agree, my lord.
PWD
That
already
also will be demolished.
PWD already encroached 20 decimal. 50 decimal is side there, is there. And all the percent is 50% already there.
My lord, kindly see page 33.
So what your authorities are doing, they are not indicating what is the nature of the plot.
My lord, the sketch map, I was not there, but sketch map is not clear whether the PWD encroachment on the PW area or not.
This only shows the PWD road.
Only road.
There has to be some
Actually,
area.
Actually,
Yes.
if there
On the
is
sides of the PWD road,
yes,
some area of the PWD has to be there. But the
there may
sketch
be.
map has not indicated that.
There may be, my lord, the space.
Has to be, not maybe. Has to be a
Not
PWD.
always there, but sometimes the space are kept vacant for widening the road.
Yes.
Sometimes.
Yes.
My lord, before the contempt court, my lord, at the time of contempt, 5 times, my lord, attempt, BLRO could not, my lord, demarcate for the agitation. That is why he stated that it is my work. I have done everything. Before the executive magistrate and 200 police, my lord, went there. After that, the demarcation was done. Page 33, clearly, my lord, they have stated, yes, we have constructed unauthorized structure on PWD road. They have, my lord, stated. And my learned friend is also saying, my lord.
Several percent, my lord, not only 4%. 20, 30, 32%.
My lord.
Petitioner himself.
My
his shop is there. Petitioner himself,
My
his
lord,
shop is there.
total,
on the PW road.
total.
Cause an inspection, remove everyone.
Yes, my lord.
Including the
My lord.
Including the petitioner.
Yes, my lord, including the
Whoever
petitioner.
is encroaching.
My lord.
Whoever is encroaching the
Hey.
petitioner, my lord.
My lord, APTB, sir.
PW road must be clear.
My lord.
PWD area, not only the road.
Yes, PWD area.
PWD area, yes, my lord.
The petitioner
Number 19, I beg to appear on behalf of the application. So, my lord, this the complaint against the private respondents. My lord, this lordship kindly come to page 11. See my
Private respondent, what the private respondent has done?
my lord, this is unauthorized construction. Kindly come to page 12.
And for
So
the
now
for the state one.
For the state, yes, what is your instruction?
My lord,
But that since my lord, the police has been implicated as a party respondent, my lord, I have received one instruction from the concerned police station, and my lord, from
Neither here
no,
nor
my lord, the admitted construction is there from before on the roadside land. Now, whether this land belongs to PWD or not, that is my lord, the BLRO after demarcation can be ascertained. But the police my lord, says my lord, the construction is there. One
You have a copy of the Highways Act 1964.
আচ্ছা তুমি বার করছো না
Highways Act আনালেন না
আচ্ছা কপিটা আছে
Highways Act is also provides that adjoining of the PWD land, kindly come to page 13. This is this picture, it is clear that the PWD land I have. Kindly come to picture I have.
কম্পাউন্ডিং আছে
It's the adjoining.
দিয়েছে
Section 12.
Section 20.
Section 12, my lord, kindly.
12.
1, 2. Even it is adjoining, necessary permission is required from the my lord, the highway authority. So first of all, section 10(1), it has to be ascertained by the BLR.
well, section 10 give the
first
procedure
On the bend, if anyone wants to construct, 12 is a different thing. It's not that the land beside that highways is also highways. That does not say.
Bend. Or.
That is
Or
so that it
corner.
obstructs the view.
So now, my lord,
That's the purpose.
if your lord is prima facie, my lords, if it appears from the my lord is on inquiry, I was present at the time of my lord, the police, and if prima facie it is my lord, kindly come to page 12. So 13. So there is a my lord, let them to authority be decide whether there is an unauthorized construction or not. If it is found, section 10.
So you have made a complaint to the assistant engineer.
Yes, assistant engineer, execute. Yes.
Mr. Ghosh, the assistant engineer is the appropriate authority.
Appropriate authority under section 10. If he is satisfied, then forwarded, that will be forwarded to the not prior to that.
No.
The first step is one of the by
Yes, he has to make an inquiry. So he has to make an
Who is
inquiry.
the assistant of the BLRO?
Yes, that is, let him do that.
Let them do.
Authorized shall serve an notice.
section 10 wala says.
If it is,
No, first is section 10(1).
10(1).
He has to come to a finding.
Thereafter,
serve a notice to remove. Not done, then executive magistrate.
thereafter, the
Section
10(3). 10(4).
There is the procedure. This is the procedure laid down by this honorable court. And my lord, there is another judgment. My lord, this honorable High Court held my lord Justice Jyotirmoy Bhattacharya reported in 2012. So that is also adjoining. That is that define the what is the adjoining plot of the PWD in that Prodibata.
In that matter, the question arose whether that has been declared as a state highway or not.
Let them to declare.
Honorable court says even if it is a PWD government land, that is also covered under this act.
Then my lord is a section.
Where have you stated that the PWD road that highway has been obstructed, which paragraph?
Malad, the paragraph 3 I have stated. Malad, if your lordship kindly state away my complaint of page 15. Paragraph 3 I have stated, but the page 15.
Your plot is 137.
1137. 1137.
1137.
1137. You have said 137.
But the representation on page 15.
B 137.
What is the correct one?
Malad, kindly see my
137.
137. Record of rights.
Representation ভুল আছে
137 is the correct number.
Malad, record of rights.
Mr. Ghosh, where from you are saying 1137?
Malad, page 15.
Malad,
Representation before the assistant engineer,
one-
paragraph 1. মহাশয় দাগ নাম্বার 1137 মালিক হইতেছি।
No, but in the Bishoy it has been.
In the Bishoy 137 is written.
The petitioner claims to be the recorded owner of Yes, who is appearing? None appears for the petition at the time of call, no accommodation.
My lordship, I am for the petitioner, my lord.
Yes.
My lord, petitioners, there are three petitioners.
Please move to your left. They have to be given some space.
There are three petitioners.
Side to the petitioner ऊपर से आ जाते हैं. Yes, yes.
My lordship, the petitioners are the owner of the land. My lord, I have annexed the Xerox copy of the ROR and also the purchase deed of purchase. My lord, our land has been using by the respondent authority for the purpose of mineral pipeline, petroleum and mineral pipeline.
Underneath your property.
In my property, my lord.
Underneath your property.
Under my property, my lord.
Yes.
I have annexed the purchase deed also.
Yes.
But my lord, till date, they have not given us any compensation for the using of my land, my lord. That is why, my lord, I have filed this writ petition. I have given the representation to the authority, my lord, annexing page 68, my lord.
Page?
Page 68, the representation, and their notice is page 64, 63, annexure P2. They have given the notice. Hearing has been taken place. We have appeared at the hearing, my lord. They have only get the signature of the petitioners, but no compensation has not been given by them till date.
Yes.
My lord, in this writ petition, I'm appearing for respondent number 3, but my lord, the respondent number 2 has been wrongly represented in the writ petition. The respondent number 2 is being described as the chairman, Indian Oil Corporation Limited, my lord. But in this particular case in issue, my lord, the Indian Oil Corporation Limited is not a concerned respondent, my lord. My lord, because
that can be corrected.
my lord, secondly, my lord, the cause of action in the writ petition is non-disbursement of compensation. My lord, I have taken instructions. The work has not yet been commenced. There has been a hearing being given to the petitioners and all.
The order you have passed on the hearing.
My lord, the order has been passed.
Where is that order?
My lord, the order is being annexed in the writ petition, my lord.
Where?
The order by the competent authority. My lord, the order of the competent authority.
The order of
my
the
lord,
competent
my lord.
authority. Hearing notice has been given.
My lord, hearing notice have been given. The orders have been passed, my lord. This is, yes. My lord, the order, my lord, the petitioner was also represented in the hearing, my lord. It's not that, yes. My lord, the order.
No order has been passed.
My lord, orders has been passed. My lord, my instruction, specific instruction is that the work has not yet been completed, but the petitioners and the others whose land on whom these pipelines are to be constructed, all are to be laid, my lord, they are liable to get compensation, but that has not been yet quantified because the work has not yet been completed according to the Act, my lord, and all the rules and regulations of the Act are being complied with, my lord.
Please communicate this order to them.
My lord, already 2 years have been passed.
Their
work has not been.
Work has been done.
Yes,
work has been done.
No, they
Then
continue.
they have not. If they have not utilized your property, why they will pay compensation?
My lord, we have given another proposal to them, my lord. As the land is they are cultivating on that land.
You cultivate. Nobody is
yes, because
nobody is disturbing you till now. They have not. They may withdraw their proposal. They may not lay their.
Yes, my lord. That's what my instruction is.
That is your instruction.
My lord, the instruction is that, my lord, as on date, my lord, as on
They have
date,
not yet laid.
yes,
They may change their
we
decision.
can accordingly change the
What? I'm directing him, please give a copy.
we'll communicate the copy of this particular.
Give a copy to
My
him.
lord, but they were represented, my lord. My lord, I'll communicate.
Why? They are
My lord, I'll
saying
communicate.
because
Subject to
they were represented, but no decision was communicated.
my lord, I bow down to my lord's observations. My lord, I'll just communicate this. My lord will kindly pass this an order. My lord will kindly observe that the respondent number 2 has been wrongly represented, my lord.
I'm giving them liberty to correct that.
Deeply obliged, my lord.
That we have another land, my lord, that may be used by them, but not this land as some portion of
They have
the
not
land
used, madam. They have not used. That is their stand.
We have not used.
Why are you
that.
giving another land? They will take away that land.
My lord, kindly record that.
No, my lord, that we not.
Don't give another land. They have not utilized your this
এখন
property.
ইউজই হয়নি এবার ল্যান্ড যখন হবে দেখা
আচ্ছা,
যাবে
আসুন Yes.
Your Lordship, petitioner is a 60-year-old widow, scheduled tribe woman, and issue is disabled, suffering from multiple age-related alignments. His disabled certificate pays his
What do
disabled.
you want? What is your grievance?
My grievance is, Lordship, I would like to.
Already filed an application because the officer.
BL.
That officer
SDO.
correct. That is the officer in backward welfare.
Backward welfare officer. Yes, sir.
That was he is not a officer.
Your Lordship, in this case, the DM is the supreme authority to pass the no objection certificate as per mandate of the
No objection. For what?
for selling the property without other than the SC/ST. No objection.
Permission.
Yes, Your Lordship.
So that is an action under the West Bengal Land Reforms Act. You have to approach the tribunal, madam, if you have any grievance.
Lordship, in this case, the disabled certificate is there. The person is so under.
Maybe. So if the I think the collector is the authority.
Yes, collector is authority. Your Lordship, kindly
The
please.
Land Reforms Act. Oh, I can ask.
Under
which provision?
Under 14C, Your Lordship.
Yes, 14C.
I approached before the BDO, SDO, and has issued. Your Lordship.
So you want to sell to a person not belonging
to the scheduled caste and scheduled
tribe.
Yes, Your Lordship.
So for that you have to approach the
I approached before the
revenue officer.
Yes, revenue officer. My representations is on page number 41, 42, and 43, Your Lordship. There are several judgments before this honorable court, which passed, Your Lordship, on by Honorable Justice Jyotirmoy Bhattacharya and Vivek Chaudhary, which entertained this type of repetition, Your Lordship. My representation should be considered so that the no objection certificate can be issued by the DM. DM is the supreme authority to pass the no objection certificate, Your Lordship.
This is in a civil suit in a second appeal.
Yeah, but
not in a writ petition.
Your Lordship, another one is there.
That is LPG distributorship.
Lordship, the land, another is.
No, that relates to a LPG distributorship.
Your Lordship,
That connection, no, it's not an inaction on the part of.
Your Lordship, inaction on the part of the
revenue officer. If there is an inaction, they are not giving.
Yes,
so you have to approach the tribunal. You have to approach the tribunal.
Your Lordship, the delay proceeding is there. The person is disabled and not able to stand properly, Your Lordship.
Please approach the tribunal.
Extreme hardship conditions are, Your
Please
Lordship.
approach the tribunal.
Please consider my representation so that I can approach.
Please.
Consider my no objection certificate, Your Lordship.
For that you have to, if there is an inaction on the part of the authorities, yes, Mr. Day, what do you say? Mr. Day, what do you say?
Representation must be considered within a time. Representation must be considered, Your Lordship. That's my only humble submission. Distress, Your Lordship, the first essential condition.
He has made a representation. Why are you not considering?
Only for that reason, my lord, I say that Your Lordship can pass down.
Consider representation only, Your Lordship. After that, we are going.
On seeing the picture, my lord, I have seen.
Where is the representation?
Your Lordship, page 41 to 43. 43, the last one is a 43.
43, last one. Then according to the provision, my lord, that is the 14C is revenue officer.
Revenue officer.
Your Lordship.
But revenue officer, you have not made any.
Concerned our representation, did not consider our representation till date. We are in extreme hardship condition, Your Lordship.
But you have to approach the appropriate authority. So I give you liberty to approach the appropriate, to file a representation before the revenue officer.
Representation is already there, Your Lordship.
For the district magistrate is not the authority.
Revenue
14C is the revenue officer.
No, I have already said 41 is 42 SDO Kalna.
SDO to revenue officer na. BLR
SPO also is not the authority.
BLR কেও দিয়েছি
বাবা
দিদি।
দাও এটা ভিডিও
Okay.
বাবা দেখে নিয়েছে এই নাও এই যে এই জায়গাটা দেখো
আচ্ছা।
প্রোভাইডেড
Revenue officer.
my lord your lordship can pass down.
So I'm directing this, giving him liberty to
Yes, my lord.
file a representation before the appropriate
my lord.
authority.
Yes, condition in civil type and I can't take it.
The petitioner And please take back these judgments. You can use it in other matters. Yes, for the next matter.
Lordship, Mr. Tapan Kumar Mukherjee is appearing in this matter for the Tapan Kumar Mukherjee for the state respondents. He's Lordship, Lordship, he's in court number 4. Lordship, he's on legs in court number 4.
Demolition of illegal
You are here. Yes.
Demolition of illegal encroachment.
Illegal encroachment of
The public land, PWD roads land.
public land or road?
Land belongs to the PWD roads department.
Public land is
No, my lord.
public land is a different determination has been
Not
given.
public land, my lord. PWD land.
That's public land. Public land, separate determination.
It is not the public land.
Land or road?
Road, my lord. My lord, given representation to the roads department.
Roads department.
Page 26.
Yes. Private respondents.
Given notice, my lord, this is the evidence of service.
Petitioner. Petitioner claims
Same and identical.
Same and identical.
Assistant engineer requested the concerned BLLR to make an inspection.
I am for
and
the private
send a
respondent,
report.
my lord. I am
You have not encroached.
not encroached. A title suit
This
is
is
pending,
the-
a title suit is pending before the competent civil court, my lord. Due to heavy grudge, he made such application, my lord. A title suit is pending between the parties.
With regard to the self-same plot.
No, variety plot. Same variety plot. But he made an, my lord,
Give me the plaint.
my lord,
You have filed a suit against him.
my lord, against them.
আর যদি না করতে তাহলে তোমার কেস করতে নাকি আর তুমি আসতে না?
Yes, yes.
Copy of what?
Yes,
Plaint.
he has very much field inquiry. Commission work is done, my lord, completed. Commission was completed.
তুমি কিসের জন্য সিভিল করে দেওয়ার জন্য?
আমার জায়গা দখল করে নিচ্ছে।
ভালো করেছি।
ভালো করে
State of West Bengal, BLLO, all are parties there.
my lord.
But,
All are what?
but I don't know which plot has been stated in this.
Which plot you are claiming?
He is claiming,
My plot is 862.
yes.
862.
In front of the land, I am claiming that that portion has been belong to the West PWD roads department.
Which land? Which land? Plot number.
No, madam, I have not.
প্যারাগ্রাফ লিখে
That's
দেখো।
why
You have to mention, sir. Cannot be vague. You have to mention what plot number.
BLRO is the authority to investigate.
BLLO is the party in the civil suit. He will decide everything. Everything, all points can be decided in the suit. State
Well, let it
of
be
West Bengal by the
sent for
collector.
consideration. Let it be sent for consideration to the authority.
It will be considered by the civil court, not by the authorities.
My lord.
By the civil court, everything, all
That
points.
needs to pending this matter, my.
Yes, Mr. Bandyopadhyay, what is your instruction?
My instruction is, my lord, we have received the representation from the petitioner. Thereafter,
You
my
are
lord,
also a party in the suit.
my lord, thereafter the assistant engineer Holdia Higher Subdivision wrote a letter to the BLLO concerned
To demarcate.
for demarcation. After getting, my lord, the demarcation report, we shall take step, my lord. Whether the land is, my lord, falling within the jurisdiction of the PWD authority or not. If it is, my lord, the PWD authority, there is an encroachment, we shall take step. And as per your lordship's order.
The competent civil court is CSN of the matter, madam. And both the parties are
Joseph
in the suit, as well as the jurisdictional BLLR.
You are the owner of which plot?
862.
He has stated, my lord, 3
862.
plots,
What is your name?
My name is my
3 petitioners,
three petitioner, my lord.
Yes,
Regarding
the
the-
union-
and they have stated 3 petitions, plot number.
Yes. And so the Rajiv Chandra Das is the
Private respondent,
private respondent. You are related,
No, my lord. No,
brothers,
no,
nothing, never.
neighbors.
কি নেবা তোমার শত্রু তো
শ্বশুর করতে পারে।
নেবাটা তো ভালো হবে এই কি শত্রু তো শত্রু আমাদের ভালো তা নাহলে কেসটা হয় না
কি দেখতে হবে? তো একই একটা করে থাকতো।
Where is the public road?
In front of my land.
In front of your land. And where the private respondent has constructed?
Just in front of my plot.
No construction is there at all. No construction is there. I am in the, I have my own rights.
Civil suit subject matter, and this is different.
I am in the.
Maybe.
I
Maybe
am-
because you are claiming an easement right of way
Wait,
over, yes,
that is,
easement right of way
That's it.
over cost schedule property, that is plot
860
number 862.
862.
862, he claims to be the owner, and you have filed a suit claiming your right of pay.
Passage.
Yes, let that civil suit proceed. Nobody is disturbing that. Now, his allegation is that he has a property at 862 and you have constructed on the public road. That's not the subject matter of the civil suit.
My
It's different.
my contention is this: I have
Mere
not
pendency of a
constructed-
civil suit
I
cannot
am
stop
not-
all proceedings.
I'm not constructing any structure, my lord.
I will record that. Let them cause an inspection. If it is found that you have not encroached, nothing you have encroached, it will be demolished. Ashun.
স্যার আমার বাবার
মাইক্রোফোন
বাবার বাবার ভিতরে বাড়িটা আরআর ডিপার্টমেন্ট বাবার কোনো কনসেন্ট ছাড়া উনি মারা গেছেন অন্য লোককে দিয়ে দিয়েছে সেই ব্যাপারে আমার কোয়েরি উনি তো কোনো এনওসি দেননি এই যে
এটা সামন সার্ভিস সেটা
সমন সার্ভিস হয়েছে সেই সেটা আর কি এটা হলো কিভাবে
এটা কি ইনপারসন আছে? Yes, Mr. Mukherjee, what is your instruction?
I have not received any. How that could be entertained by the REIT court?
Why? RR property.
RR property.
Yes.
When can you see the prayer
Yes.
at page 10?
What happened?
Originally allotment
Has
was
applied.
no. Allotment was made in favor of person.
Allotment made in favor of
A person.
And
Yes.
he was his father.
আমার বাবা
He is his father.
রবীন্দ্রনাথ রায়ের নামে কোনো কিছু
allotment made in favor of whom?
According to him, his father.
Yes.
Yes.
But
That you are not disputing, Mr. Mukherjee.
no, without
Allotment is not disputed.
allotment
Allotment in favor of his father is not disputed.
But can you see that deed?
Where is the deed?
Page number 7.
পেজ নাম্বার 7 স্যার পেজ নাম্বার 7 দেখে নাও
Page number 25, annexure 7.
পেজ নাম্বার 25 annexure 7
Page number
25 annexure 7 Freehold deed.
Yes, Mr. Mukherjee, this is the deed.
Yes.
Now, why have you not given possession?
If possession has not been given, can you see?
Possession given.
Can you see page 26? Sorry.
Page?
Page 27.
27, yes.
And whereas in accordance with such request and for the purpose of rehabilitation of the government of West Bengal by these dated demands in favor of donee for the purpose of measuring 3 cutters and 3 chatak square feet same pattern model 6 December 24 grand. In 1994. We are in 2024.
And how
1984.
how is occurred
84.
without permission of
We are in
original
this is in 1984. We are in 2025.
না না
So what?
Mukherjee, you have executed a deed. So, will you not hand over the possession? And now you are taking the ground of limitation. You have executed a deed. It's your duty to hand over possession. You will not hand over possession. Now you are taking the plea of delay. It's your fault.
He could have challenged immediately.
Mukherjee, you are in welfare state. You have executed a deed.
Yes.
But for what?
For the purpose of the
possession with you.
For the
possession with you.
but can you see what is his prayer?
Yes.
To restore the land.
To restore the land.
Hand over possession of the property to him.
No. That is not the prayer.
Yes, that was because LOI was sent to him at his number at his name. So how is LOI given to him if he is not the owner? Corporation LOI.
You are not providing the no objection certificate.
No
What is the
objection certificate
dispute?
was given.
Have you got instructions, Mr. Mukherjee?
No. That's about. I want to file an affidavit, or without an affidavit.
Where is the objection certificate then?
Have you transferred it to someone else?
Without his consent.
That without instruction, factual aspect.
Prayer.
Prayer.
ট্রান্সফার করে দিয়েছে অন্য
একদম
কারোকে।
একদম মানে
I won't give.
বিজয় রায় কানাইলাল রায় তাদের বাড়ি
But they are not been made party.
একদম
They are dead. They are deceased.
তার ডিসিজ
But there must be some legal error.
Please take instructions. Because
উনি জানতেনই না
so this deed you have
এরকম হয়েছে।
executed, you ought to have given them possession. Now, how could you transfer to to another person without cancelling this deed.
But if
How could you cancel that, a registered deed?
no, a registered deed can be cancelled only by another registered deed.
Yes, show me how have you cancelled that. And without he being a party, you can cancel that.
According to his allegation, this deed has
You have transferred it to someone else.
someone.
Without his
How
consent.
could you do so?
That challenge is made in 2025.
What?
Sir, Mukherjee, don't take that plea of delay here. It's your fault. You should have given them possession. And how could you transfer it to someone else? To whom have you transferred? Please take instructions. When?
At least 2 weeks time may be given.
Why 2 weeks time?
And nowadays, most of the government officers.
The more you take time, the elections will come. Other
No,
processes.
no,
will
no.
start.
This,
Now
sir.
just commence. Sir, SIR, whatever, just commence. Do it fast. Don't take a longer time. You will be in difficulty. Ashun.
এটা কি করে পাবো?
স্যার আমরা এটা জানতে পারবো কিভাবে?
Order will be uploaded in the website.
ওয়েবসাইট
অর্ডারটা 20 তারিখে থাকবে, উনি রিপোর্ট ফাইল করবেন 20 তারিখের মধ্যে। আচ্ছা,
Order will be uploaded in the website.
রিপোর্ট
My client is here. My lord knows my lord. I faced that problem also. My senior did not get anything.
Yes, what is this
I
matter?
get it. Now, can you see your lordship? Can you first, the second round you get page 49.
You are challenging the order dated 22nd of January 2025. Where is that? Which page?
First round 49 you are also concerned.
Page 49.
Yes.
What is page 49?
Page 49.
Order of the High Court.
Order of the High Court, my lord, previously. The land was acquired, my lord. No compensation was paid. Road was constructed. Possession was taken. Then I come to this government. Then, my lord, that the coordinate bench directed the respondent to dispose of the representation of the petitioner.
Now an order has been passed.
Yes,
What is the order?
yes, my lord. Page 50 start from
57.
55,
55.
55.
57 is order.
Dara, आगे रखा 55. 55, you're also going to first, page 56.
Yes, so
Page
it
56.
has been held that you are entitled to compensation.
Just a minute, just a minute. Just a minute. But
What is your
As per
demand?
direct
but you're also
purchase
kindly. But can you, page 58.
Page
58. Page 58. Let's start from. That's order number 4, 22nd January 2025. Previous page, page 57. That page 58, that paragraph first 1, 2, 3, 4, 5 line. Last of 3 line, 5 line. Possession was handed over to, got it? Possession was handed over to the recording body, that is superintendent engineer road such and such, for construction road from G1 such and such. By delegation such, it appears that notice understand 4 1A of the Act 2 was not published in Calcutta, hence delegation was lapsed. That is their finding. That is their finding. Then, my lord, the sample land was not utilized, not acquisition, utilized. The report was called for. They were page 62.
No, utilization is beyond the notification.
No.
Original notification.
No, utilized. Only utilized. Then is entitled to get compensation. Now, what was the order? What the order is, hence, the representation of the writ petition are considered and disposed of.
Which page?
62.
62.
Hence, after writ petition 21.
Yes.
Hence, the representation for the writ petition are considered and disposed of. All the writ petitions, their respective representation claim for payment of compensation in terms of direct purchase such and such. Now, for further compliance of the order dated such and such of the Honorable High Court, the superintendent engineer said such and such, being the S105, being the appropriate state office is requested to initiate proposal for direct purchase alone as per such and such, or such and such, to provide necessary fund to the Secretary District Land Purchase Committee, such for necessary document. My submission is that order is not bad. Not direct, though I have submitted, they were entitled to, we are ready to get compare as per direct purchase policy. What is?
You are ready.
Similar.
They have submitted. That is the representation.
Just a minute.
Recorded.
Similar order, I moved similar type of order. Yeah, this or Mr. Banerjee also appeared.
Maybe.
I this
No,
is this order.
Here we are not there.
Yes,
State for compensation.
What has been held?
As per 2013 Act. And you see, my lord, page.
Mr. Bhattacharya, are you agreeable under the direct purchase policy?
They agree,
No,
my lord.
so
They agree.
though I submitted, I am agreeable to direct purchase policy.
If you are agreeable, how can you now turn over and say I am not agreeable?
What I will do.
You have said before
But
the authority.
similar order was challenged in this court. Mr. Banerjee appeared.
Mr. Bhattacharya, there is a thing. Direct purchase policy, it's upon you whether to agree or not. Since you have agreed upon that direct purchase policy to take compensation under the direct purchase policy, so now how can you now turn around and say no, please give me under the 2013 Act?
Before that, my lord, I made application also. Made application also. Thereafter, page 64, after the order was passed. To pay compensation as per.
Sir,
Act.
Bhattacharya, please kindly come to page 62.
Last but
All the writ petitioners in their respective representations claim for payment of compensation.
Payment of compensation.
So,
Then
as per the
2000
direct purchase
yes, my lord.
policy, this
Memo-
was your representation.
বর্তমানে 2013
Now, how can you now turn
সরকারি
around
আইন
and
অনুযায়ী
say,
সরকারি আইন অনুযায়ী before the authority after passing of the order we submitted an
in the
application.
representation? In the representation, you have said, where is the copy of the representation? Please show me. Where is the
Page 62?
না 62 না তার আগে রিপ্রেজেন্টেশন থেকে
No.
Where is the representation which you have submitted before the authorities?
কোনটা রিপ্রেজেন্ট কি বলছিস তুই লাস্ট রিপ্রেজেন্ট কোথায় গেছে no before the order was
Show me
passed.
the representation before the authorities.
After the order was passed?
Not after the order was passed.
Before that, prior to that?
Yes.
Prior to 40.
Page number 40.
Page 41.
Page 41.
41.
One.
Kindly see, they have mentioned the memo, 756 memo, অন্তর্গত
42, yes, 752 is দুটো
প্রতিসরণ পাইতে
such
পারি,
and such.
তাহার ব্যবস্থা করি। No, page 41, Lordship, last paragraph.
Page 44 also.
সে
Page
কারণে
44.
মহাশয়ের নিকট আবেদন যাহাতে
Oh, yes, 756.
756
Yes.
Yes, so
I'm carrying.
this was your representation.
We submitted before the authority concerned. I am not saying that. It is similar, the type of order was challenged before the other coordinate bench. I handed over the judgment. Kindly see.
একটা কপি দাও।
Kindly see.
So that there was also an agreement.
No, no.
There are also more.
No agreement.
Mr. Bhattacharya, if a proceeding has lapsed for non-issuance of a notice
For yes.
41A,
Yeah.
the proceedings for requisition under Act 248, that's to lapse.
To lapse.
Now, in the meantime, the
13 Act.
48 Act should expire. The lifetime of the 48
Expired.
Act should expire.
Expired.
Now, it was open to the authorities. So here it was a case of 41A not invoked. So they could have resorted to 9(3) capital A.
Neither that, don't notice has been yes.
Allow me to get.
Yes.
They could have, I've said.
They could have.
They could have invoked 9(3)A.
Yes.
Your case is that 9(3)A was also not invoked. So the requisition proceeding was not converted to an acquisition proceedings under the 1894 Act.
Yes.
It was not done.
Not done.
In the meantime, Act 1 of 1894 also stood lapsed. 2013 Act has come into
Yes.
force. Now, your case is that after the coming into force of the 2013 Act, till then they have not paid you compensation. But the fact that your property has been utilized, that's not disputed. That's
That
not
was
disputed.
Yes.
So you are entitled to compensation under the 2013 Act. There's no dispute with regard to that. There's no
Yes.
quarrel with that proposition.
Yes.
But it's direct purchase policy. It is an offer and acceptance. They can offer. It's upon you whether to accept or not.
Yes.
Once you have yourself has offered, they have accepted. How now you can come out of that and say, no, give me compensation under 2013 Act. Please satisfy me on that.
Only matter that, can you see this, only two paragraph, can you see?
Yes.
Same submission was made before the coordinate by Mr. Banerjee also.
Show me whether on that case also this fact was there, that there was an agreement to accept compensation under the direct purchase policy.
That's similar. I can bring that order also.
No, no,
We
this order-
submitted,
this
yes, we are
order,
ready.
Please show me that fact. Mr. Bhattacharya, the decision has to be considered in the lights of the facts of that case.
So I
Show me
can
the facts.
I shall
For
bring
me
that.
to apply that case to this.
I shall bring the
small
judge.
piece of
I shall bring the retribution also. Copy of the retribution. I shall bring.
No, no, the point was not considered and in the
Can you
judgment.
see
Please
this?
show me in the judgment whether
Can you see,
that
madam?
issue was considered or not.
Yes,
Mr.
yes, yes.
Bhattacharya.
Mani page paragraph 6, page 2.
Paragraph
6.
Yes, show me.
Consider হয়নি দাদা।
চুপ না দেখে দেখে জোসেফ রিজি করে করবে
খালি
it is
আমাকে-
submitted by Mr. Bhattacharya
খালি
that
আমাকে-
while passing the said decision order Resolution 3 also practically came to a finding that though process was initiated for acquisition of land or the such and such to publication of notice under such and such but no notice under section 4 1 year such as was published in the gazette, no error was also declared. The further submitted Mr. Bhattacharya that from the said decision order that such as it would be revealed further that responsibility authority without adhering the provisions of Act 13 passed order for purchase of land of the petitioner under direct purchase policy scheme. It is submitted by Mr. Bhattacharya that the respondent has passed such decision order without giving the due adhere to the law as envisaged in the Act 13, and therefore appropriate release may be granted to each petitioner in terms of period made in the instant writ petition. Par contra, Mr. Banerjee, an advocate appearing on behalf of the state respondent and his instrumentally submit before this court that admittedly the requisition proceeding has been lapsed on account of non-publication of notice under for such and such. And therefore, the respondent authority rightly passed the order for purchase of land or the writ petition under the direct purchase policy. That factor there. Then 7A out of the court. Now, can you see 11, paragraph 11. Such being the position, court finds that cannot be any predicament in directing the respondent authority, more specifically respondent authority, to initiate a fresh proceeding for acquisition of land of the petitioner with effect from the date of taking possession.
Yes, please, I have read this.
Your Lordship,
Next paragraph also.
Yes.
Please kindly come to paragraph number 12.
Paragraph 12. It is
Yes, yes.
court while passing the order for direct opted for direct purchase.
Yes, who opted? Please see that. Who opted in that judgment? Please see.
Opted right on the basis
Who
of
opted?
Respondent authority.
No.
Respondent authority.
Please see. The respondent number 3, authority has opted.
Respondent authority has
Not the petitioner.
So 3 opted.
Yes, it's a reverse case. Here you have opted, they have accepted. So what is it?
Then acceptance and offer and acceptance.
Yes.
Contract.
I've seen that.
So that is on that count,
Why?
Your Lordship, offer and acceptance.
That is why I was.
Contract offer and acceptance.
How long you will continue for that? Because
Then, my lord,
50
another thing. Another thing. It is a direct purchase, right? Then, my lord, Superintendent sir, direct purchase price payment of such and such. Then, my lord,
Mr. Bhattacharya, have you taken?
there is no time limit. What can you see? Can you see?
What?
For to provide necessary fund to secretary such and such, along with all necessary representatives.
Bhattacharya, I can do one thing.
Yes.
If your client is
Agreeable.
to take as per the direct purchase policy, I can direct them to file an affidavit. Within what time they will conclude, release the payment. But first take instructions from your client.
From my client. Yes.
Whether it is agreeable. Then
your-
Mr. Banerjee, how soon you will do that? You have to
Affidavit.
file an affidavit. You will
File.
conclude the entire process. Sanction, everything. Conclude, including payment within. Yes, Mr. De, how much time was granted?
Oh,
Mr. De is the architect. He has suffered this order, 2013 Act.
Yes.
Then, yes. Then after that, he has came out with, he has taken out an application for modification, stating that he is agreeable. Thereafter, the writ petitions also said, yes, I am also agreeable.
Agreeable,
That is why I am asking you.
The
Please
agreement.
take instructions from your client. How much time? I fixed 3 months. 4 months.
4 months. Mr. De,
4 months. Mr. Bhattacharya, there is a series of procedures which are to be complied with under the direct purchase.
they will say, the authority say that we are very much, we are busy for anything. Then SI,
Nothing.
after that saying,
No
SI,
busy, nothing.
no.
Time limit, the end date is given, if not
Yes.
2013 Act.
Yes.
If not 2013 Act, that's the order. Because I have passed an order under 2013 Act, it was modified. If the time limit expires, that will revert back.
The petitioner will not delay. If any consent or anything is required from the petitioner, he will immediately comply because he might delay, petitioner might delay.
Oh, delay for
Who
taking
said?
in the
No,
process.
consent I will record here.
Yes, yes.
If so, I will direct the petitioner also to file an affidavit. He is agreeable
Very
because he has challenged here.
Yes.
So he has to file. But please take instructions. If your client is agreeable, you have to file an affidavit. That
Within a week.
Within a week. And if that is done, you have to file an affidavit stating that within
Yes.
this time,
Yes, yes.
specific time,
Yes.
you will comply. If not paid, 2013 Act,
Yes.
you have to pay that.
Yes. Ooh. So he is the author.
Who is the author?
Mr. They.
Yes.
Yeah?
Yes, yes. Then authority in land
Authority.
matters that.
That one is the authority. We
Uh,
are very happy for Mr. De.
That concession was after he suffered an order in contempt.
In contempt.
That was in contempt.
They are the suffered in a contempt in a division bench in my matter.
In contempt, then he said that he is willing to.
In that matter, they is not going that good a division bench in a contempt.
Since the consequence would be there, my lord, in case of failure, it shall go to the 2013 Act. Some more time may be required.
What?
If they fail, my lord, then it shall go.
Automatically with expiry, I will make those observations.
That is why, my lord, I am
আবার
taking
আবার
some
কি
more
হচ্ছে
time.
অনেক কিছু চলো আজ অনেক হয়েছে চল
Yes, next.
Number 27.
27 on behalf of the petitioner, my lord. This is the case of removal of illegal encroachment from the PWD roads land.
Removal of encroachment.
Yes, my lord. Lord,
Yes, Mr. Dev, why are you allowing encroachments on public?
My lord, this is my affidavit of service.
Why are you not taking prompt steps, Mr. Dev?
My lord, most of the cases now land, my lord. Encroachment.
There, but you cannot deny that there are encroachments.
Yes, no.
Maybe some cases there is no encroachment, but you cannot.
My lord, in Calcutta, my lord, if I want to go to the road, every things, my lord, every day, my lord, there. Almost.
My lord, page number 16. My representation.
Considered by the respondent of height.
Respondent number 5
5
is the assistant engineer.
Yes, my lord.
Who has encroached?
All the private respondents. All
the
private
private respondents.
private respondents, my lord.
You are the owner of which
Yes.
plot? 800, 801.
That is paragraph 2.
Plot number.
800 and 801.
Yes.
Petitioner claims to be the recorded owner. One petitioner.
Yes, my lord.
Well, Mr. Shopun, my lord, Mr. Shopun Banerjee is appearing for the state in this matter, my lord.
Who is appearing?
Mr. Shopun Banerjee.
Yes.
On his behalf, I am paying for an accommodation of one day, my lord.
Yeah. Sorry, yeah. Yes, yes, yes.
Substantially is the similar matter. The previous
What
matter-
similar matter?
Largely encouragement of pavement of
No
Grand
civil
Tank
suit.
Road.
So you are appearing, there is no civil suit.
No civil suit.
Difficult to believe. There is no civil suit, you are appearing.
My lord,
Page 49, Lordship, I purchased the property in the year 2022, annexed P1, my registered deed. My lord, I sent some letters to the different authority and as well as the executive engineer PWD.
It's found that you have also encroached.
No.
If it is found upon inquiry, you have also encroached.
my lord, may I hand over the report, my lord? A report has.
Let me see the report. If you have encroached that, then that will be also removed.
Joseph জানে আর কি বলবো আমি বলতে পারবো কিছু I already annexed photocopies.
You want to install another gate on the
On the
side
southern
where the
side,
private respondent has made a.
on the southern side.
You want
of
to
the-
install a gate.
Yes, I don't get. Lordship, kindly see the photographs.
Civil dispute.
Kindly see the kindly
It's a
see the
civil
photographs.
dispute.
Surrounded
I told you, you are appearing, there is no civil suit. So you file a civil suit now.
Lordship, surrounded by wall. Kindly see the photograph on the pavement of the Granting Road. On the pavement of the Granting Road, which is on the southern side of my land. He is running business of temporary by making temporary structure of scrap materials, Lordship. And not only that, he threatened me not to enter into my house, enter into my land.
This structure is not on the road.
Yes, yes, on the pavement of the Granting Road.
No, no.
Yes, yes, on the
Beyond
pavement.
pavement.
Kind-
This is the structure at page 36.
At page 35.
Page 35.
35 na 36. And it's a
No, no.
P2.
Page 36. Yes, P2.
And it's a P2.
P2. This is the structure which has some iron rods here. This structure.
Yeah, this is the same structure, Lordship.
Yes, yes.
This
This
side,
is
side structure.
not on the road.
This is the pavement. This is the pavement which is on the southern side of my land, and on the back side there is the Central Bank of India. My land is situated on the southern side of the pavement of Granting Road. Granting Road is a national highway, NH 19.
Which is your property?
My lord, surrounded by wall. Proceed, kindly see next page at 37. Surrounded by wall. On the back side of the temporary structure and in front of Central Bank of India. That is two-storied building. In front of two-storied building, Central Bank of India, surrounded by wall. Surrounded by brick wall.
Where is Mr. Banerjee?
My lord, he has left court for some personal difficulty, my lord.
So this is a report from the inspector in charge.
Yes, my
The
lord.
inspector in charge, competent person to say whether there's an encroachment upon the.
My lord. I have no instruction, my lord.
Let a report be assumed. The petitioner alleges that the private respondents
9, my lord, I appear on behalf of the petitioner. Lord, in respect of a sand mining block, Lord, gold sheet 2, Lord, I was, Lord, the highest bidder. Lord, the highest bidder. Lord, I could not deposit the 1/3, my lord, deposit in terms of, my lord, section rule 10. Now, Lord, in 2018, Lord, they cancelled the auction and forfeited my amount. Lord, I made a representation to them that there is a provision in Rule 12 of the auction rules, which says that if any amount is due and payable in terms of any auction held under these rules, then, my lord, interest at the rate of 6.25% per annum would be charged. I said that I am agreeable. I am agreeable to pay the interest which is provided for in the statute. Lord, this representation, Lord, has been.
Why it was cancelled?
Because I could not, Lord, deposit the 1/3 amount within time. Admittedly. Now, Lord, the auction rules, Lord, don't provide for any.
So you submitted a representation.
Right.
What happened to that? Rejected.
That has been rejected belatedly.
Order.
Lord, belatedly, I have approached them. That is, Lord, the reason. Lord,
when it was cancelled?
2018.
2018.
Representation 2025
after
7 years.
May I?
Does not challenge the cancellation order.
May I? Lord, only thing, I am not conscious of this. Only thing is that.
He knows everything. Yes, yes, Mr. Chaturvedi.
Yes. Only thing is that this land, Milord, has not been put to, Milord, fresh auction once again. So no third party right has been accrued. Milord, the state
be put to auction.
May I?
Maybe you are the highest bidder. Put that amount.
May I, Milord, put, Milord, this, Milord, my proposal in course of my submission. I say that when I agree to pay the interest in terms of the statute, the government is gaining interest for this entire period. Now, I can't, Milord, pray.
If the price escalates,
I can't.
At a rate more than the rate of interest.
That is, Milord, not what is stated.
Maybe.
But
so
I
participate. I will allow them to hold an auction. Participate.
Just
Be the highest bidder. Maybe at an amount lesser than the amount which you quoted plus the interest.
Yeah.
Maybe you will be gaining.
Yes,
but
yes.
Participate in the
Yes,
next
but
auction.
no difficulty. But I can't make that prayer because the question is one of distribution of state largesse. I can't say that you hold an auction for this. So I can't, Milord, pray a mandamus for that.
No,
I have.
No, I'm not saying.
My lord.
Not for praying for a mandamus to direct them to hold. Whenever they will hold auction, you'll be at liberty to participate.
Now,
in that.
if it is, Milord, if it is, then, Milord, it goes to the discretion of the respondents who have not held an auction in respect of this, Milord, sand block for this long period. I am saying that I am agreeable. I am agreeable to pay you the interest for the entire period in terms of the. Kind of, Milord, have a look at the rules.
Yes.
No, Lordship, the only difficulty is this tender was I am for the respondent number 5.
My lord, that
As
now
on date after 2021, there is a new rule.
Respondent number 5. What
Yes,
is
West Bengal Mineral Development and Trading Corporation Limited.
You are conducting this auction.
yes.
As on date, because
As on
this particular auction was conducted by the district authority in terms of 2016 rule, West Bengal Minor Mineral Concession Rule 2016. In 2021, the state government introduced a new sand mining policy followed by a new sand mining rules. After promulgation of 2021 rules, my client has been designated as the nodal agency for the purpose of conducting auction. So as on date, the auction would be conducted not by the district authority who cancel the tender, but by Mineral Development Corporation. So this, as on date, it would be conducted by my client, not by the district authority.
So whoever conducts that,
Yes, if it is put into auction, there is no bar for the petitioner to participate.
Yes. Now, yes.
Now, Milord, yes. Milord, kindly sees, Milord, Rule 12. Milord, kindly sees Rule 12. The state government shall charge simple interest at the rate of 6.25% per annum on any payment due to the state government under these rules for the period of delay to be calculated on the expiry of 60 days from the date due for such payment. So whenever this date
became due, I am agreeable to pay rate of interest, my lord, prescribed under the rules, 6.25.
Mr. Chaturvedi, can a mandamus be issued for that?
No, I am now,
Mandamus be issued for
my lord,
that.
yes, now kindly see, my lord, the impugned order.
I'm asking you, can a mandamus be issued for this?
My lord, if my lord,
The prerogative of the state government, they can charge. But can it be in a other way around, a defaulting party, whether he can approach the court seeking a mandamus, directing the state government to accept this interest at that rate and to
that is in case when it is not cancelled, my lord.
this type of a mandamus can be issued.
with deepest of respect, my lord, I say, my lord, yes, because the rules, my lord, they do not provide for, my lord, cancellation on the anvil of delay. They provide for what consequences will follow if there is a delay. The consequences are penal in nature to the extent of enriching the state exchequer, but not punishing the bidder. That is, my lord, the scheme.
That's the statute permits the state, but I'm asking you whether a mandamus can be issued. It's one thing whether the state has a right to charge interest, and it's another thing the defaulting party comes and says, yes, state, you accept this and give me that. This is the mandamus. That's the lies the difference, Mr. Chaturvedi.
My lord, no, I fully appreciate. But the mandamus is to the extent of not seeking, not quashing of the memo, which says that we have.
Mandamus, you have to show that you have a legal right, and they have an obligation to perform. Failure to perform that, mandamus will follow.
Yes.
So show me that you have a legal right to claim that at a belated only upon payment of interest.
My lord. Now,
that right, subject to Rule 12, does not give you that.
Only thing, my lord, kindly see, my lord, 52. I have sought a mandamus seeking quashing of this memo.
Yes, quashing of this memo, consequence is according to you. You say, I'm agreeable to pay. Please accept this amount and give me that.
Yes. Kindly, my lord, permit me. Why they have cancelled it? They say that you have delayed. That is the only reason. They don't say that
the order of cancellation.
Page 52.
Yes.
Lord, last but one paragraph starting with the words as
52 is the cancellation.
My lord.
So you said that you have made a representation, thereafter an order was passed.
No, so this is that cancellation of representation.
Initial, what happened? This 2018, you have said it was cancelled.
Yes.
That is page 42.
That was not challenged.
That was not page 42.
This has no reasons, my lord. Hence, I was showing page 52. Page 42.
All 17 my lord auctions are cancelled. যাই হোক সবগুলোকে অ্যাকশন ক্যান্সেল করে দিয়েছে ওটা শুধু ওটা তো আইটেম নাম্বার 14 hereby cancelled.
Yes. Serial number 14.
Terms of para such and such of the bid document. So the bid document must contain some clauses.
Yes.
Pursuant to which this was cancelled. Where is the bid document?
I come to that.
Page 21 starts from page 21.
I come to.
So, Mr. Chaturvedi, after this was in 2018.
Yes.
Now, what steps did you take thereafter? You have filed a representation.
I have filed a
Where is
representation.
that representation?
My representation.
When did you file that representation?
Yes. My representation is below 2025.
28th August 2025.
And
After
that
7
is
years.
একটু বলে দিই আমি তো
আচ্ছা বলো ঠিক আছে
page 43.
Yes. So Bandyopadhyay, allow Mr. Chaturvedi to exhaust himself.
I'm trying to help him.
Yes.
He's not found it.
And when the back is to the wall, it's very easy to get exhausted.
Yes, yes.
Lord, page 43.
Yes, page 43, yes.
Yes. Now, Lord, kindly sees, Lord, the sum and substance of my representation. Lord, I have, Lord, explained why I could not. I do not want to get into the, Lord.
You might have explained the delay by giving some reasons.
Yes. Now, why it has been rejected, they say at page 52.
Yes.
Lord, last but one paragraph. As you had failed to deposit the 1/3 of total bid value within due time, a show cause notice was issued with a number so and so duly received. However, as per records, you have neither deposited the 1/3 amount of the bid nor submitted representation against the said notice.
Notice was issued to you.
Yes.
You did
I
not
was
reply to that.
I was not in a position. That is my explanation.
Sir, Chaturvedi, the show cause notice was issued to you.
Yes.
You did not reply. Now, consequently, the bid was cancelled. That was in 2018.
My lord.
Now, at that relevant point of time, some authority was conducting this process, auction process.
Yes.
Now, you have submitted a representation. At a point of time, the law has changed and another authority is now empowered to conduct this auction. So now whether the erstwhile authority who has cancelled can now take a further decision on your representation at this point of
Has
time.
taken.
That is representation. They do not have any authority. They could have simply said one line, we do not have any authority to consider your this representation at this point of time. That would have been sufficient.
Then will kindly set this aside, kindly grant me liberty. I shall make it to the present authority, no difficulty. Because the only thing is that
And the representation is challenging an order of cancellation of 2018. And that's the subject matter. And you are approaching the root court in 2025 merely because a decision on your representation has been passed on 8th of September.
the short question which I am on is that why the state is not accepting. The ground is that delay. I am saying no third party right has accrued.
Yes, are you contemplating to hold auction now?
Yes, Lordship, in every occasion, as soon as the district authority, they supplied no objection that you can put this particular sand block into auction. As and when the no objection came, we issued the
participate in an auction. Maybe the amount which you have to pay together with interest, the auction price may be less. Why are you taking this risk?
I shall, madam, I bow down. But will my lord
state largesse,
if
the
my lord
maximum price which can be fetched, that is to be taken into consideration.
No.
So if by auction higher price is they are
may I make a representation to the current authority who let them take a decision if they arrive at a conclusion that together with the interest, whatever amount is arrived at and I am agreeable to pay is less than what they are contemplating to keep a reserve price, then they will reject my representation. If it is more, they may very well accept. I do not know.
No, I could not follow your submission.
My lord would set this aside because the authority has got no jurisdiction in terms of the 2021 policy having come into force. Since that is not the reason of the order, I have not challenged it. Now, set this aside, kindly grant me an opportunity. I shall make a representation to the competent authority who is authorized to take a decision presently.
What?
Not for allowing me
this cancellation cannot do because Mr. Chaturvedi, authority A has taken a decision. Authority B cannot reconsider that decision. Cannot be done. Cannot be done.
A proceeding initiated.
Proceeding initiated by authority A. Whether authority B can cancel that? Cannot.
And the interest part which Mr. Chaturvedi is submitting, that was in terms of 2016 rules, not in terms of 2021 rules.
These are the difficulties. Now, because in the meantime, the law has changed. Another authority has come.
The law has changed only with regard to conducting the auction. The entire thing remains within the domain of the Ministry of Commerce.
Mr. Chaturvedi, the authority conducting the auction is the authority who can take a decision with regard to cancellation.
It's the same department.
Maybe the same department.
Ministry of Commerce.
Yes, but now it's the corporation which is the authority. If now the authority, the corporation conducts an auction, it's that authority who can cancel. The erstwhile authority who has taken a decision to hold auction, that authority was at that relevant point of time the appropriate authority to cancel. Now, I cannot give you leave to file a representation before the corporation because they cannot reconsider the decision of Mr. Bandopadhyay's client. There lies the difficulty.
I have also sent it, although a copy was sent to the present authority as well.
They cannot reconsider that because you are, in a way, seeking to review the decision of cancellation. in effect, reviewing representation is to review. Setting aside, you can give a different name to that, but it's in effect reviewing the cancellation. Please review that, set aside that, take interest and allow me. That's your purpose. So cancellation was done by Mr. Bandyopadhyay's client. He could have, at the relevant point of time when he had power. So that was till 2021 or 2022, that power remained with him. But once the law changed, a different authority is now the authority to hold auction. So he does not have the power to reconsider that decision also.
My lord, in an identical matter, if I may, my lord, indicate to my lord, when an order was passed by a coordinate bench, and my lord, the authorities, my lord, have extended the time for payment of the 1/3 amount, and this amount has
If
been
the
paid.
authorities are willing, I have no issues on that. But the question is whether a mandamus can be issued.
Cannot be.
The authorities extend, I'm not.
When
you say
when I my lord make a prayer, my lord, I make a prayer, my lord would consider. Now, in all cases, wherever even mandamus is, my lord, kindly sees paragraph 9 of the order.
But
Paragraph 9.
Chaturvedi, whether these points arose in the earlier round of litigation or in this matter?
No, I say, blood government contracts, government's contract similarly placed persons in similar difficulty are cannot be not differently treated. That is not violation of article. My lord would not permit this. If I would, my lord, if this is a question, then my lord, I need to address my lord on
the
this.
bid document.
My lord, yes.
Starts from page 21.
Cancellation.
Rejection of bid 10.7, page 29.
10.7 is page 29.
29.
Yes. The bid document cannot override the statute under which it is being issued. If there is a conflict, the statute would prevail.
But you have participated in the auction as per this.
I say to the no.
So now whether you can challenge that after having participated?
No, I say no. I say if a conflict arises.
Yes, Mr. Chaturvedi, you could have challenged at that point of time that these are the conflicting conditions not have been done. I do not accept that. But participating in a tender on the basis of these bid documents, whether you can challenge after you are unsuccessful or your bid has been cancelled, invoking any of the powers.
Milord, kindly sees this, Milord, 10.7, this ends the moment my bid is submitted.
Yes.
So after this, they can't take recourse to 10.7. To the extent that they rely on 10.7, I say is inconsistent to the rules.
No, reserves the right to reject any bid and not to annul the bidding process and reject all bids at any time without any liability.
Yes.
It's the absolute prerogative of them
Yes.
to reject anything.
Milord, the bidding process ends after, Milord, the H1 is declared. So they can't take recourse to 10.7. This is what I'm saying. That if they take recourse to 10.7 after the bidding process is over and H1 is declared, then that is an action which is inconsistent with Rule 12. Because Rule 12 says that once your liability is saturated, then for the period of delay, 6.25 is what you are to pay. I find, Milord, no place in the rules or in this bid document that after I am declared H1, they can take recourse to cancellation. And today I am only saying if this authority is not competent, let the new authority consider. And my proposal, it inures benefit to the state exchequer.
Mr. Chaturvedi, why are you shying away from participating?
I am not, Milord. I say for this long period, Milord, for this long period, Milord, this was not put into auction. Now, Milord, for this period, entire Milord state machinery, my Lord knows, Milord, is busy elsewhere. It's deployed elsewhere. After that, my Lord knows, Milord, where it will be deployed. So until the next summer seasons, my lord, there is no auction, my lord, process in my understanding. My lord, I may be wrong. My learned friends would, my lord, correct me if I am, my lord, wrong. My lord, I say today I have the resources that I can enrich the state exchequer. Let them consider that. Here is a citizen who says that the government is facing a loss because of me. I have understood this. I am volunteering to pay.
If they're agreeable, no issues, Mr. Chaudhary.
Let them consider.
Mandamus cannot be.
No, I am not. Again,
Consideration has been rejected, Mr. Chaudhary.
but not by the competent authority as rightly held by my lord.
And against the rejection order, my lord, there is a provision of appeal under Rule
Against?
15. Against the cancellation order, rejection order, there is a provision of appeal under Rule 15 of the concession. 51 of the concession rules.
These rules, 51.
51 before the divisional commissioner. But that has been, my lord, cancelled in the year 2018. Rule 51 of the
Rule 51 of 2016 rule
2016
says that any order passed by the district authority can be assailed before the divisional
But he has not preferred any appeal.
This is, my lord is looking at the auction rules. The concessions rules will be before that. Now again, as
per the concession rules.
It has been commented as per concession rules. Rule 51.
In view of the
As the auction, my lord, held in terms of the auction rules, my lord, 2016.
they want me to rely on
mineral concession rules.
They want me to rely on the provision of appeal of a rule which according to them is no more existent.
At that relevant point of
That is the point.
now,
That
Mr.
is the point.
Chaturvedi, that
That cannot
time
be.
period will expire, law will change. Now, thereafter, when you think you will approach the writ court and you will say, yes, no,
This
that rules has been
particular rule is
amended,
effective as on
appeal
date.
provisions.
My lord, I say, my lord, I am, my lord, today, my lord, I say that I am only guilty of delay. Now, this delay part is taken care of by the rules. The rules do not say that 6.25% is limited only if there is a delay of 2 years, not more than that. Because the
rule that is
the
you are right.
legislature
That you are right. You do not. It does not say
because the legislature. I'm sorry.
Limitation that after that this interest cannot be charged because, Mr. Chaturvedi, it's a power given to the state government.
Because, my lord, the
State
legislature
government
in its
can
wisdom.
charge. There is no limitation to that. But the question is whether you have a right to say that I will pay this. Please allot it to me.
I say I can't
take the ground of delay. Cannot cancel. Please accept this and give me that subject.
I fully bow down. I fully bow down. My lord, what we say, my lord, in service jurisprudence, we say that you don't have a right to promotion, but you have a right of consideration in accordance with law. I am only saying today.
Here is also you do not have any right for consideration. It's the prerogative of the state government whether to charge that or not. You do not have any right to say, yes, you have to consider my case of charging. That right also you do not have.
Deepest of respect.
Rule 12, it's the power of the state government. Mr. Chaturvedi, there are line of decisions. Giving power of an authority to an authority, whether for not exercising that power, whether a mandamus will can lie. You have a right because this does not give you any right. On the other hand, it has the power of the state to charge. If you have defaulted, maybe let us not take it for 6 years, maybe 1 or 2 months. You have delayed, they can charge you for that.
Now, kindly see the language employed.
No,
but it says not shall.
No, I'm not for a moment saying that yes, it cannot be charged after 2 years. I'm not saying that,
my lord.
I'm only saying it's the state's right. They can charge, but you cannot say yes, you have to charge. There lies the distinction.
I say kindly consider accepting my bid on the anvil of Rule 12 and charge me because you are empowered under 12. What does he say? What does he say?
Empowered is one thing. It's their conscious decision whether to charge or not. You cannot say, please take this, give me. This is the distinction, Mr. Chaturvedi.
Lord, I am asking for consideration, my lord, and I again say,
Consideration,
I am
Mr.
only asking.
Chaturvedi is all right without going into that, but once a decision has been taken, and this is a legal issue, now without deciding this, I cannot direct them to consider. Eh, You know, there lies the difficulty.
My lord,
Whether you have a right, unless you have a right
my lord,
for a consideration of your prayer, cannot be directed.
my lord, I have already detained my lord for a little longer.
No.
I
No issues on that
I,
because
my lord, I only, my lord, subject to my lord's consumption.
you also moved matters in the other determination, so there is no issues on that. You can
My lord,
continue even after 4:30.
my lord,
if you are willing. I'm
I
not-
know. My lord has been benevolent.
Yes.
My lord, I was only making this submission to my lord. My lord, either, my lord, set this aside on two grounds. One, that the authority had no jurisdiction. Second, my lord, it could not have been, my lord, rejected on the anvil of delay because Rule 12 is founded on the delay element. So it could not have been rejected on that ground. If my lord does so, with a liberty to me to approach the authority, the competent authority will very well reject me, my lord, and I have again,
The use purpose, Mr.
my lord,
Chaturvedi,
my lord,
because
this again, my lord, I kindly sees, my lord, I am armed with an order. Now,
that is
my lord,
why I'm asking you whether these issues were raised, considered in the coordinate bench.
my lord, available to the
It has
respondent,
an authority
available.
for the proposition what it decides, and on the facts of the issues raised. Please show me that these issues were raised.
My lord, kindly,
Authority
Lord,
do
sir,
not
may I
have-
just clarify the
kindly
point
permit
raised
me,
by Mr.
kindly
Chaturvedi?
permit me, একটু বলে নি বাবু।
না কেন ওটা হয়েছে? His Lordship,
বলি
in
না তো,
some
থামতে
cases
তো আমাদের
where
মধ্যে।
the LOI has not been cancelled, in that cases where there are administrative batches for which lease could not be executed, in that cases LO government by issuing a comprehensive order, LOI was extended for a particular period, enabling the participant to obtain all clearances. But in this particular case, Lordship, the tender has been cancelled. There is no question of granting interest at this stage following Rule 12. Had the tender not cancelled, in that event he could have paid for.
Mr. Chaturvedi,
my lord,
I can direct exchange of affidavits later.
kindly, my lord, do that. My kindly also, my lord, protect me to the extent that in the event if auction is declared, this the pendency of the writ petition will not preclude
Yes,
me
there
from
is no bar. It is goes without say.
I think that was the order which you could have got without these affidavits. That is the thing
No,
which
but,
have-
no,
He
my lord,
can
but
have
this, my lord, I was
There is no
beseeching,
participate in the auction process.
I was beseeching my lord, because of this. My lord, in my learned junior's chamber, my lord, both the clients, my lord, come, they sit together on the chairs side by side, one armed with an order passed by this court, and another, my lord, armed with an order of rejection of this court. Lord, how does he reconcile the conscience of both the clients? Is also, my lord, a concern which, as an officer of the court, my lord, I have.
Senior advocate, you will advise him how to deal with those.
No, as I say, as an officer of the court, my lord,
Sufficient experience to deal with in this type of situations. There are very many stories you also are aware what happens after change of determination. One order passed, another may not be.
This
because
but the issue, whether the issue was raised or whether the issue,
the views may change.
No doubt about it. My lord is, my lord, putting a query to me, my lord, I was about to answer that. Whether these issues were raised. I say the issues were available to the state. So whether issue estoppel will arise or not, this issue was available. It was a defense available to the state. The 2021 policy has come now. The authority is bereft of any jurisdiction. So if it is
You are on constructive res judicata. Constructive res judicata, there has to be a pleadings on that.
It's a question of law.
No, question of law, whether these was raised, these were considered.
I am relying on a
and Mr. Chaturvedi, you know the decision. If these points are not considered, the issues raised, it's an authority for a proposition. The issues which were raised and decided. Merely one or two sentences from the, you cannot call out from the judgment and say this is what is the ratio of that judgment we have to see.
Lord, writ
That has to
jurisdiction
on a facts of that case and a slightest difference in facts.
My lord, writ jurisdiction, writ jurisdiction,
line of decisions.
writ jurisdiction, my lord, we always, my lord, wonder, my lord would exercise my lord's magnanimity. The question is, I am sorry.
Yes, no difficulty on that. But there are some issues. If it goes, whether you have tried to invoke Rule 12, whether Rule 12 can be invoked at the instance of a defaulting party, or it's the right of the state. This is a distinction. You cannot, when it's the right of the state, the private party cannot come and say, yes, yes, please exercise that right. There are decisions on this line.
My lord, it is the other way around with, if I have understood.
Decisions on service jurisprudence you will be getting. Look, there is a power of review,
my lord,
given to an authority.
My lord.
The authorities may consider that. But whether you can file a writ petition and say, yes, please exercise that power. No.
My lord, it is, in my humble understanding, the other way around, that the
That
the government
have considered that and have passed orders sitting in the division bench.
But the
on this.
But the
on this,
respondent,
whether in this type of cases, a mandamus can be issued.
but the respondent is saying, I will not exercise powers in Rule 12 because of delay. I am not challenging this, that your understanding of Rule 12 is erroneous because Rule 12 is founded on the element of delay. I am challenging the understanding of Rule 12 by the authority in rejecting. They say that you have delayed. That means their understanding of Rule 12 is wrong. The judgment itself becomes erroneous, it's vitiated, because the understanding of law by the statutory authority is erroneous. That is not the ground on which it is vitiated.
So, Chaturved, there are two ways, directing exchange of affidavits and giving you liberty, or disposing of the writ petition, giving you liberty.
Liberty to make a representation.
No, not representation. If they undertake auction, you will be at liberty to participate.
No,
That is what you have said.
Milord, no, I have not said. In that event, kindly permit me, Milord, to seek a prayer for exchange of affidavits, granting me liberty to participate in the auction if
they decide to.
Yes. I am deeply obliged, Milord. And my apologies to my lord, Milord, for detaining.
For detaining your lordship in this, because after
No apologies.
Lord, my affidavit of service may be taken.
Affidavit service filed in court today is taken on record. It's the order of the coordinate bench.
My lord. And the book. I'm grateful.
Book you are not gifting to the court, Mr. These are the rare books, Mr. Chaturvedi.
This thin a book. My lord, how dare, my lord, I have the audacity of gifting to my.
No, at times, Mr. Chaturvedi, it's difficult to fetch.
It's
those
already
books.
a very
library.
it's already a very rich library, I know. It's already a very rich library, I know.
But look, I do
Yeah.
not have any books here.
26
Soon, very soon, I go. Grateful to my lord.